Well, good morning, everybody. I have 10 o'clock. John, JOHN at support. Are you ready? John is ready over there. Iris, if you would call roll call, please.
Chief Stan Stanridge.
Here.
Assistant Chief Jessica Anderson.
Present.
City Manager James Devlin.
Here.
Lieutenant Clifford Drake.
Here.
District Attorney Carlos Garcia.
Here.
HR Director Christy Lewis.
Here.
Mr. Robert McCabe.
Here.
Mr. James Parnell.
Here.
Captain Dennis Rice.
Here.
Chief Victor Rodriguez.
Present.
Mr. TJ Smetzer.
Here.
Ms. Jennifer Shemansky. Here. And Chief Deputy Jason Moore. Have a quorum.
All right, thank you. Jenny, I don't know if we've met you, have we?
No, not yet. I'm the newest Assistant General Counsel of the team.
Okay. Is Aaron here or no?
He will be here. He will be here at 10 o'clock.
All right. Well, sir, would you like to start off on behalf of TCOL?
Okay, certainly. Thank you all for being here again. Happy Thanksgiving and happy holidays. Glad to have everybody back here. Looks like we got a full house. Appreciate all the work that y'all have done so far. It is a note. I believe this committee has made great progress in its work product, and I think it's very thoughtful and it's been very thorough so far. We appreciate all the efforts and all the organization and the time that you've all put into it. And I think we got a great starting off point today to move forward and to meet our deadline. So we appreciate that very much. Thank you all.
Yeah, I think the ops tempo has been really good. This gives us a buffer. We can either finalize these today, and then my recommendation would be go back into our respective agencies and then go over the suggested model policies with your agencies and with your legal staff and see what they think and or believe is missing, and then come back one more time in January to finalize it. And then I presume we will present to the commission in February?
That's correct.
Okay. And I would imagine several of us would be present for the presentation to the commission. So, does anybody have any other thoughts about meeting one more time in January after we take these back to our agencies to plug holes? Does that sound doable? All right. From my co-chair, do you have any welcome comments or thoughts?
I don't.
All right.
Ready to going.
All right, Mr. John, JOHN, let's start with, you have that one up, but can we go to the actual policy? Do we need this one up, John, or you?
Where do you want to go first? Do we want to go with the, you want to do minutes first, or do you want to go dive right into this?
You need to do the minutes. Sorry, minutes first. Has everybody had a chance to review the minutes? If so, I'll entertain a motion for approval.
Motion approved.
Do I have a second?
Second.
All in favor signify by saying aye. Aye. Any opposed? Motion's approved. All right, now we can go to the sample policy. All right, Iris combined the sample policies into a single document. So assuming you can see those, we will start here. And Jim, I believe this is mostly yours, so do you want to go through it?
Yeah, no, I like how this ended up turning out. Especially after Assistant Chief got wordsmithing on it. I don't have any issues with it. I think it meets the criteria as what was intended, and I think what the legislature wants. We're gonna do investigations. The majority of us are gonna do investigations on these anyway. At least this makes everybody start. Those that haven't been doing it.
And Iris, did you say I have this? Did you give me this printout?
Yes.
Oh, it's right here. Got it. There is a comment on here. You all can't see this unless John puts the comments on there. It says, rather than define the terms in the text of the policy, it seemed easier to break them out at the top. Not married to this, but just offering a consideration. Whose comment was that?
That's mine. So when we talked about it in the group, we kind of had it all jumbled up together, but in the interest of making it look more like a policy, I figured it would be easier just to put the definitions at the top with the understanding that those terms carry the definitions throughout the text of the text. So I don't know if you guys want to do it that way. It just felt easier to me than putting it jammed up in there. But I didn't want to make the change without identifying it for you guys and for conversation if necessary.
I think that's always personally, I think it's user friendly by doing that. And it certainly, you'd want, I think leading with that is a great idea for a variety of reasons.
And so the next point for consideration is that I defined it as misconduct, not serious misconduct. We had the conversation about the differentiation between serious and not. And so I don't know if we want to leave it as defining serious misconduct or just call it, say, this is the definition of misconduct for purposes of this policy. I don't know the answer to that question. That was the second comment that I included. So you'll see in investigation, it says we shall investigate allegations of serious misconduct.
I think we can take serious out.
Okay.
That's, I mean, you have the definition of misconduct up here. I think that we can eliminate that.
And the statute does say misconduct, so we're not creating something that's out of tune with what the bill says. I think I agree. You could delete the serious, and you've defined what misconduct is. I don't think that extra adjective is required there.
Yeah, and again, I just didn't want to make a unilateral change and make it appear that I'm like sneaking stuff by or whatever. Just
Sure.
the comment was to encourage the conversation, make sure we're all talking about the same thing at the same time.
I have a question about unlawful searches. I've toyed around with our administration. We were looking at it, and the question came up about good faith searches. So the officer thought he did a good faith search. Everything looked good, no problems. Sent it to the district attorney. After the district attorney looks at it, he said, that probably wasn't a good search. He acted under good faith. He thought everything was good. It was not like he was out doing trying to do an illegal search. My question is that what we're looking for? Do we need to put something about good faith in there, or just that was a question that was brought up in some of our discussions moving forward?
I'd say if it's good faith, it's not unlawful.
It
almost have to be like a good faith. It's almost like a criminal act.
Sure. I'm not. It wasn't a criminal act, but when they say it wasn't a good search, does that mean you present a case to the DA and the DA says, nah, probably wasn't a good search? It wasn't that he was out doing an illegal one, but it just wasn't. You know what I'm saying?
Yeah.
So does that mean every one of those that you
It's
present?
the fruit of the poisonous tree kind of thing.
Are we going to have to go back and investigate that?
I just want to point out that this is going to be a model policy.
Correct.
And the implementation within your agency can have additional information if you believe necessary. So let's not forget that. You don't have to adopt it, from my understanding, word for word verbatim, correct?
Well, if this is going to be the model policy, this will be the model policy. One can go more specific.
Right.
But certainly
Couldn't go to
they can't define out of this.
Right.
So that's what worries me. If we put this, then we're going to have to, every agency is going to have to conduct an investigation on every one of those type things. That's what I see.
Well, what if you're looking at, we took the word serious out of under number 2 for investigation. We don't want to put it under misconduct, but why don't you add the word serious alleged violations of, because then if you get a minor violation like a good faith violation, you can say, I didn't take it as an administrator to be a serious violation. I took it as a minor violation. I think maybe that gives you that leeway to say, I used my discretion because I didn't think it was a serious violation. So add the term serious.
I land where Jason landed, where there's a remarkable difference between an unlawful arrest and a search that we're pursuant to a fruit of a poisonous tree. This one's not necessarily unlawful. The way you got to it was the derivative of versus unlawful. That's a hard
The DA
threshold.
doesn't usually say it was an illegal search. Like they said, it wasn't a good search.
Yes.
There's a training component or something, and that would be my suggestion is this last line of the definition, misconduct does not include minor rule violations of less serious nature. I think I would address what you said, that might be resolved by other corrective actions less than a suspension, right? So to make it clear where that differentiation lies, there's a lot of things that we correct through something less than a suspension, that is not misconduct. And that would be, if it's not a good search, that there's a training component where they didn't understand how this current case law applies in this particular situation. That wasn't an illegal search, it was a poor search that requires training to correct.
Yeah, because that's what I was gonna say. When I'm reading this, I'm thinking unlawful search is something that goes a little bit, it's not a bad search.
Right.
There's bad searches that, hey, you know what, on the side of the road, an officer's making their decision in a split second. When we get it, we're dissecting it, we've got all the time in the world to kind of tear it apart and then say, well, you know what, I think you took too long, it probably delayed, to the point that, I don't think we get there. That's not that the officer did anything wrong. Then I've also had officers where evidence starts coming in that maybe they're making up information in their search warrant because they got that gut feeling and they can't develop it. And that, I think, is where we're trying to get to with this and not the.
And I agree. I just wanted to voice that.
No, I think we need to have it clear because you're gonna have, unfortunately, I guess everybody's had good and bad, people that have been involved in different agencies. But sometimes those bad people are at the top of that agency and they end up trying to use something like this to get rid of somebody who, shouldn't be gotten rid of. I mean, I've had guys that should have been an internal investigation and they got the Rangers on them and then that causes a whole lot of stuff and we're looking at it and the Rangers are looking at it saying, we should not have been investigating this. This was not this kind of a situation, but it was an administrator who was trying to maybe get rid of that individual. And so we wanna, I think, make sure, we're protecting it from the top and the bottom too, because, you leave it a little too open, somebody's gonna take the opportunity to use it for what we're not intending it for it to be used for. So that's the only comment I wanna make, cause I've seen that happen and, there were good officers that luckily, were able to, weather the storm, so to speak, but they shouldn't have had to weather that storm. There should have been some protection that I think, maybe is there some place where we can put comments if we don't want to put it as a rule where, just where it kind of gives what the intent of that is, we don't want to put it directly into the policy, at least for something to give some guidance to that next person that's going to be reviewing it and having to decide how they apply it.
I think that is a great idea in order to give some guidance to the chief administrators out there, because obviously you have tension here. One, to where you don't want this to be seen, or this committee doesn't want to be seen this as a tool used against a licensee for an employment purpose. That was a good faith mistake that turned it into a bad search, but it wasn't necessarily an illegal search intentionally violating someone's civil rights. But on the other side, you want to make a policy that's broad enough to where at the end of the day, the next prospective employer can see this type of information and make a determination, whatever the case was, whether or not, well, yeah, that was a good faith mistake. The point being, I think, is there can be, and again, remember that this policy will require a chief administrator to initiate an investigation. This is a triggering event here. So sufficient guidance. I think maybe with an explanatory note, we could try that out. We're working through this draft towards its final form pretty quickly. But I think that's an idea, and I think you'll have plenty of time to work with that to kind of at least put those thoughts down and digest them and see if that's maybe something that needs a little more explanation, if that makes sense.
So what if TCOL differs with the chief administrator?
As far as?
Whatever the interpretation may be.
I think.
You think they should have triggered investigation? I read it a different way. I don't. You're gonna come after me because I didn't do it? What happens in that circumstance?
I think there's sufficient guidance in here to where that's gonna be kind of in the prudential judgment of the chief administrator. It's just like whatever form.
That doesn't answer the question though. What happens when?
Well, I was
Tico-
almost, let me finish the rest of it. It's just like the F5 forms. We would get, well, someone wants to prosecute a chief administrator, what is TICO going to do if you don't agree with what's on an F5? The facts and circumstances of whatever that F5 designation was, whether it was honorable, general, or dishonorable, those are within the control and knowledge of the chief administrator. And they have the judgment, local judgment and understanding where they can fill that whatever box was. We have no judgment over that. It's similar in this situation. Obviously, a judgment call on an unlawful search, and that goes back to, here's a committee, we've got to come up with something that's sufficient guidance. If there's something that's a judgment call, that's the judgment call in the chief administrator's hands. However, if it's something blatant, if there is an action that is so blatant that has not been reported or investigated, obviously, I mean, it's hard to answer that question if we're talking about a criminal act that has been not reported or investigated. What are the facts and circumstances around that? What did the chief administrator know? That's hard to answer without knowing the facts.
You say reported in that statement, what are you referring to?
The investigation.
Reported or investigated.
Correct.
To TCOL?
Correct. To go in the
We'll get to that,
confidential
I guess,
database.
further.
Yeah,
Okay.
that's right. That's right.
So when you're saying, John, we'll just go back to I know the F5 is changing, but if Austin had some officer that's under investigation, or Dallas did, criminal investigation, and the chief marks general discharge, TCOL doesn't investigate and they go, wait a minute, this guy's got a bad charge here. I mean, he might go to jail, but the chief just gave him a general or honorable. There's nothing TCOL does about that.
That's correct.
Okay.
Which to me reinforces the notion that I hate to get into the intent of a policy. Those are typically done through a case-by-case basis as afforded by the judicial branch versus what we're trying to do. The legislature seldom gives us their intent when they pass laws.
Yeah, and the purpose of this being an open meeting is we're reading intent into it right now in this meeting, and these are open. And so at any point, if they want to understand what the committee was thinking, they can review this. And that's what we do in the legislature is go back and listen to hearings and what's been said on the floor and try to understand what the intent was. And, you know, they're deliberate about doing that sometimes. I think we've been pretty deliberate about it in here, what we mean by these changes, and we're still going, but I think this is a pretty good way to do that if someone wanted to.
And the thing is, intent, obviously, the first way to look at the intent of whether it's the legislature, whether it's any regulatory provision, or the model policy of this committee is the plain language of what's in front of us.
Yep. And I think everybody's intent here is to focus on serious misconduct.
Let me ask, can I ask on misconduct? We're defining misconduct here in this model policy. Yet 1445 has a different definition for misconduct. So which are we gonna be held to?
It's like we talked, Chief, this committee can put parameters on what that misconduct is. Again, what is the requirement for a chief administrator to investigate?
I'm talking about defining misconduct.
Well, yeah, if you define misconduct, you have to define that in order to see what the requirement is on the chief administrators.
Right. So Senate Bill 1445 defines misconduct. This definition of misconduct is somewhat inconsistent with that. So which one are we going to?
Where is it inconsistent?
Well, misconduct means this, a violation of law or a sustained violation of a law enforcement agency policy, an allegation of truthfulness, again, keyword sustained.
I think one
We're gonna
difference
get to
is that this is a policy, a model policy to be used by the departments, not necessarily
I know,
statute.
but we're defining misconduct.
In a model
for-
policy,
For
so
that
it's
agency.
different circumstances.
We're defining it for when you have to conduct an investigation right now.
And you don't know the outcome.
Correct.
You can't presume to know the outcome So 1445 will presume that you know the outcome. We don't know that. I have a different, not a concern, I have a different addition possibly under summary report. It dawned on me when I read everything that's articulated there, there actually is no agency disposition. What did you do with it? Did you suspend? If so, so that's, to me, the only thing that's lacking is, okay, what did the chief administrator do with it? Do y'all think that should be in there?
Yeah, and I think I intended that for the last bullet, the investigative findings, but you're right, that should probably be investigative findings and disposition.
And disposition, because the investigative findings come from IA, then I do the disposition. Yeah, okay, that would resolve my only concern there.
And where is that under? The summary report?
And then
John.
that to be reported after 30 days, after separation.
After separation, or if you wanted to. John, over at support, can you put and the investigative findings and dispositions as to each allegation of misconduct? It's the final sentence under summary report.
PDF.
We can add it.
Oh, it is a PDF? Oh, sorry.
So even if an officer doesn't cooperate and leaves the department, all you can end up saying is inconclusive, or how do you define that, or how do you determine conclusion or summary if the officer doesn't cooperate, witnesses don't cooperate, and you don't have all the evidence? What do you say?
Well, you gave me the worst case hyperbole, but I've had numerous officers resign in lieu of termination, and I was still able to substantiate and sustain misconduct based upon witness evidence, ongoing criminal investigations that ultimately leads to an arrest, as an example. So I didn't need their cooperation.
In those cases?
Yep.
But in others, you might need witnesses, or you might, to make a definitive conclusion, summary. So how would you conclude something if you really don't have all the evidence? You don't have it. You didn't.
Well, I've had that and complete it to as much as the best that you can. Because again, ultimately at the end of the day, it's for when I'm looking at your officer.
Right. For the next hire.
For the next hire, for me to make the decision. So yeah, I've had them where you can't make a judgment call on whether they've been sustained. You just put in as much information as you can, and the disposition ends up being officer resigned during investigation. And I think that's
with no opinion from
with no opinion.
No
yeah.
opinions.
I mean, and at the end of the day, the reason that we did it is because when somebody did go to look to hire that individual, that they looked at it and went, "Ooh, sure, we need to visit that." Whether they talk to the prospective employer or whether they come to the agency and get whatever they can, And again, it's at the end of the day, it's so I can make a decision on picking that person up. So I think that's part. I mean, I've never been really told how to do it. I just have done it under 143, and our employment attorneys have never said anything bad about it.
One more time, the language on the bullet point under summary report, please.
Jessica suggested that under summary report, the final bullet point, and the investigative findings and dispositions as to each allegation of misconduct.
What are the disposition options?
Termination, demotion, suspension, those are.
Yeah, I think that kind of goes to James's point, and that was a conversation that we had internally. I don't know that we have a disposition that would fit somebody who leaves during the pendency of an investigation.
So to me, a summary report, the end of that summary report would be a summary of how it ended. Like that, to me, that kind of, a summary report wouldn't just end with, it would naturally end with how the investigation ended. Like, I don't know if we need the disposition, just because that, to me, in my mind, is starting to get back to the whole F5 thing where we've got, okay, which box is it? This is supposed to be a summary of how this happened. And the end would naturally tell the next agency how that occurred. And it would also, I think, kind of force them to read the entire report instead of say, oh, what's the checkbox? What was the disposition? That's what we're trying to get away from.
My concern would be if you go to a school for internal affairs sponsored by the Texas Police Chiefs Association, they're going to teach you to do what's called an investigative summary as an IA investigator. And you're gonna articulate from the inception of the complaint all the way until the resolution from your investigative perspective. You're gonna recommend sustain, exonerate, not sustain, et cetera. There's not an actual disposition until the chief executive gets the summary, which is a standalone document, and does his or her own disposition. So you're saying you're okay just knowing this?
I mean, to me, it's either sustained or it's not. That's.
And you don't wanna know what the agency did with it afterwards, if it's
I would,
sustained?
but I would just assume that that would be in the summary report of how the investigation ended.
That those are the investigative findings.
Correct. Just like any other.
The problem is procedurally, it's a very, very different document, but that's, I can only articulate for TPCA.
I'll add that, going back to the language of the statute again, what needs, submit summary report including disposition of investigation and informational findings in a timely manner. That's
I think
from
we
the
should,
statute.
we should say what those are then. If we're gonna do that.
Sure.
We need to,
Break them out.
we need them to know what those dispositions, what the options are. And I think that's an important piece
Would
to
you
it.
agree that dispositions are no action, demotion, temporary suspension, indefinite suspension? What are the other dispositions?
I mean, I think more importantly, it's whether the conduct was sustained or unsustained. Because you could sustain an action, but not do one of those other things, just because, you know, you didn't feel it was appropriate in that circumstance. So,
But you're gonna take no action, so
but then are we still letting the next agency know whether it was sustained or not? That's my point.
yeah, so remember, the investigative findings is one thing. That's where the investigator says, hey, this is not sustained. The disposition is, what did I do with that not sustained? Did I agree and take no action? Or did I disagree and I do an administrative corrective action, like a reprimand? To me, that's the disposition. I've got to know both pieces of the puzzle. Am I wrong? Am I reading the tea leaves wrong? I wanna know the disposition.
I just think we need to lay them out there in the policy.
I'm fine articulating the dispositions. You have no action, you have administrative corrective actions, which are your LORs, your LOCs. You have temporary suspension, you have indefinite suspension, you have demotion. I don't know any other disposition out there, do y'all? That's an indefinite.
Excuse me, the summary report is gonna be a form that TEQL is gonna create, right? Or no?
Certainly can. And we can come, as a committee, I think that would be, maybe address some of your concerns, Jennifer.
And to be clear, I added this definition. I don't know that we fully fleshed it out, what summary report was, so I just included what the summary report is for investigations that I'm familiar with. And these are the things that they include, so I made it up. With the hope that TCOL would not create a form and that we could just keep doing what we're doing.
Yeah, I hope we don't create a form. I'll echo that. You will change IA procedures for every agency in here if y'all create a new form.
Yeah, I'm with you on that. I don't think the form, I think we can do it without the form, and that's what I'm trying to get to. But I think it should be done in here.
So you're okay with dispositions, you just want to define what a disposition is?
Yes.
Okay.
As long as, I think for reporting purposes and uniformity across the state and hiring standards, I think having it in the policy would be very helpful, so everyone's speaking the same language.
So we could, instead of adding dispositions in that final sentence, we add a new sentence and the disposition findings of each allegation of misconduct to include no action, administrative corrective action, temporary suspension, termination, I'll call it, most people call it termination or demotion.
We want to do termination and / or indefinite.
Well, I would,
since
you know,
majority
your
of
no action is to me different than an exoneration. So your no action, your administrator may be like, okay, well, I'm not gonna take any action on that. But if it's a false allegation or allegation that was made in haste or whatever,
That's a good point.
you probably need to have something on there that's a full exoneration.
Good point.
Because to me, no action's kind of a neutral deal, whereas if it was, you know, like I said, a completely BS allegation to begin with, we need to be able to note that. That way that doesn't carry on with that yet.
Do we want to put in unsubstantiated as well? So that's not exonerated either.
Not substantiated?
Yeah, unsubstantiated.
And I'll tell you, on the kind of perspective of a smaller agency, I would like a form. Maybe at least have the option to have one. So some of these guys that don't do IEs all the time,
Sure.
these smaller departments, it would be handy to go to the, TICO website, download something, print it out, that way you have everything that you need on there.
Understood.
You don't have that option you have your own IA division kind of thing that handles everything, but these smaller outfits are held under the same burden, and these guys don't have that ability just to refer to IA and do a report and move on.
And I think that speaks to the principle that we all discussed. This, in large part, speaks to agencies who do not have this in place, this procedure in place, the processes in place. So that would certainly be able to, and so the smaller agencies would not be having to create entire new policies and procedures. They could use forms that were created, obviously, which reflect the committee's policies in lieu of already established policies at larger agencies.
Yeah, because I think if you have that, it's going to be easier for them to do it, and they will actually do it. Versus if not, they're going to look at each other and be like, I don't know how to do this mess, and it'd be easy to skip over. But it'd help your staff to be like, well, no, we provided a form for you to fill out. So your failure to do so is we give you all the tools that you need.
And again, I just want to stress the end user in all of this is going to be the prospective hiring agency. So whatever they can see, and we're using the same language according to the model policy across the state. However we get there, whether obviously agencies who already have these policies and procedures in place, and smaller agencies or other agencies who don't have that, we can supplement with form and procedures on the TCO side.
So does this capture what your agencies do, this language? I tried to be all inclusive. This would be a standalone, separate bullet. And it would say, and the dispositions of each allegation of misconduct, including exonerated, unsubstantiated, no action, written reprimand, temporary suspension, demotion, and/or indefinite suspension termination. So you could be exonerated, it could be unfounded, it could be a written reprimand, it could be temporary, it could be permanent, it could be a demotion.
What wording did you use last time instead of written reprimand? Administrative?
I use administrative corrective action, but some people won't know what the hell that means. But everybody knows what a written reprimand is.
I just think it gives you more leeway. You could do verbal or written, or you could do training, or you could.
We use administrative corrective action, but I didn't know if everybody else did.
Is there a reason you're being so specific? Why not just the exonerated, sustained, not sustained?
I leaned toward that too.
Just
Because if you sustain it, I still don't know what you did with it. Did you fire them? Did you demote them? Did you terminate them?
You're the prospective agency.
Right. So don't I need to know that? You sustain an allegation of
TCO's
misconduct.
gonna know if that officer still works there or not. I mean, and they're applying for a job at your agency. So their status as an officer and whether or not they're with an agency is gonna be unknown.
I guess in my mind, if you sustain an allegation of, let's say, excessive use of force.
Use untruthfulness. I think that's the best
Okay,
one.
use untruthfulness. You sustain it. Oh, great, I got Houston's report. They sustained an allegation of untruthfulness. Okay, what'd you do with it?
read the rest of the report to find out.
I can't because you're not requiring it in policy.
Yeah, I am. You have a synopsis of each statement, you have a description of the physical evidence, you have all relevant information and the investigative findings.
But what did your chief do with it? Did he fire the guy? Did he reprimand him? Don't I want to know that as a hiring agency?
You can know.
How?
You can ask for the file. So this is to be turned in at the end of 30 days or after he separates.
Right.
If you're in the process of applying and you run into that, you can't know. You can ask TCO to get us to submit the file to you. And so there's a process now that came about the last session or two, I think it was. The flag comes up, you want to know, you can know.
Or I could ask for the summary report that we're supposed to provide by statute that actually says I'm supposed to put the disposition in there.
That summary report won't be there if he's still working.
That summary report, right.
Because it would be separational.
Right. unless agencies do a timely basis and submit as they do them. That's correct. Because remember, we're giving them options.
If we do what we say we're gonna do, I don't know what we're gonna do.
All right, what do y'all want to do for a committee?
I think the summary report should give you a good idea of what happened with the allegation and the investigation. It should include whether the allegation was sustained or not, and should include what discipline, if any, was given. And then if I want more details about that investigation, then I go to the file. But if I look at it and say, hey, there was a sustained allegation of untruthfulness and this individual got a week off or a month off, maybe that's enough for me to say, I'm not interested in this candidate, move on.
So you're in favor of providing dispositions? Correct. All right. Everybody else speak. Christie, you've been quiet.
We did with the dispositions as well. I think that's important to know then. Well, I mean, we're statutorily required to put disposition in there. I mean, that's in the statute that they wrote. But how do we want to work it? Do you want to say sustained, not sustained, exonerated? Do you say sustained and then suspended, sustained, terminated, and just kind of do it that way? I mean, that's an option. Instead of having 6 or 8 different options, you know, it can narrow that down.
What's your preference? Do you want to have the sustained and, or are you just comfortable with sustained? That's the question before the group.
And that's how far out do you want to go to? How easy do you want to make it for the administrator to get that and go sustained and they terminate it? Okay, but there again, you're going to know that.
One of the issues I have with this is completely off of what we're actually talking about, which is the personnel, which is the files and the security. We've talked about that these are allegedly going to be completely confidential databases. My problem with, I don't know that I am secure with that comment, but my worry is
What's your concern?
if we get really in the weeds about the disposition, like for example, written reprimand, there's a lot of issues with things like written reprimands or corrective actions that are being contemplated currently in terms of what is in a file, what can be released, what can't be released, what's considered protected and what's not. So again, you know, if it's internal corrective action, I just don't know if that's something, if this is ever something that in any case would be open to the public, then we're opening up another can of worms as far as what's out there, what can be, you know, taken on a PIR in certain circumstances when it gets really in the weeds and really down into what should be internal corrective action, but as we've seen, is now being exploited and used and being given to the public, when really it's supposed to be an internal corrective action. That's the big, to me, I see that as being a potential problem down the road with.
So when it's being given, is that intentional by the agency or the city?
Because in cities that aren't 143,
Yeah.
they don't have, I mean, some of them are protecting it right now in their own little way, and whether or not that's being challenged.
Correct.
Yeah, so
So
the AG's already that's pretty ruled on about the G file. I mean, that's a pretty,
Yeah, but
That's already
what
done,
hasn't
so-
been established is whether or not you have to keep the G file and what it actually is and what's actually in there.
yeah.
So that's what's all being debated right now and still will continue to be. It's not, the ruling that we got was good and was positive.
Yeah.
But it's not a final adjudication of it because we have and San Marcos is about to deal with the same thing. We have local ordinances that they're trying to pass that will undermine that. They're trying to undermine that file, and it's permissive right now. The file itself, the maintaining of the file itself is permissive. So that's the only, I mean, that's going like way far out of what, it's not the concept that I don't like, the disposition concept of it. It's going way beyond that.
Mm-hmm.
I just don't know, maybe the attorneys can chime in and I can get more reviews on it, but and then I have another separate question too. What we just brought up and I'm a little concerned about, we're giving them the option to do this upon separation or to do this as you see fit for just administrative purposes. My question there is, if you have an officer who hasn't been terminated or disciplined or anything, but maybe they, at one point in their career, were under investigation with your department, but it was, you maintained and you're still at that agency. And then you apply for another agency. And let's say that agency went ahead and reported it to TCOL. Now, the prospective agency, are they going to be able to access that, even though they were never separated from the current agency where they work? That's something we haven't really contemplated.
Okay, if your question is someone who is currently appointed and is seeking employment with the prospective hiring agency and has signed a consent form to the prospective hiring agency to see their documents, absolutely.
That happens now.
Yes, I agree. Happens now.
The current
employing agency.
So in other words, basically anything that would have gone there anyway, they would have gotten through the same means as Secure Share.
Correct.
Okay.
Now that's true with the G-file exception that came across before. Now that's true as an applicant process. The other question she was raising, and just so that we're, I think, clear here, and we've mentioned this before. I mean, this is a camel's nose in the tent, regardless of what assurances we try to lay out here. If I get a file from an agency through TCO, and there are documents there that I'm not supposed to have, and they're protected, and all this kind of stuff that we talk about here in terms of restrictions and all that. And at some point in time, some information from that document is going to get into my background, and that background document is going to become public information. So some of that starts leaking. Not directly, but in a roundabout way anyway. So just so that we know, to address her first question, that begins to happen to some extent, depending on how we do this.
I think that's going on right now. I mean, especially with Texas Secure Share, since we haven't had a information request on one, but I've had that same concern where we've conducted that background, we've done our summary on the background, and we don't hire that applicant. It goes over to Human Resources.
Yeah, that's true.
Yeah.
I agree with that.
Yeah.
But here, there is no option to not investigate something that comes to your attention. Now we're saying everything must be investigated.
Right.
Okay. So every investigation, every outcome is going to be, at some point, can be. If I'm a hiring agency, call TCO, give me this file, give me that information, and let's say it's a restricted document, not founded, it was a BS document, whatever it may be, all that can be true. But I'm doing my background for my agency, I'm gonna make a reference to, by the way, I found this and this and this, and once before, 10 times before, this and this happened, although it never went anywhere. Boom. So that's part of my background report, irrespective of the documents in hand. What I'm saying to you, at some point, that background report is gonna be leaked out. And so it's a backdoor way to information that probably should not be out there.
I think people have the ability to do that today.
I think.
And I don't disagree with you. I'm just saying that now it is.
Yeah.
Now that everything's in the soup pan.
Yeah, I got you.
All right.
I'm sorry, Stan. So I understand this concern, make sure I'm clear on it, Chief, the concern is once an agency has looked at confidential for their eyes only documents through the confidential database, Secure Share as we know it now, and then they create the background investigation. The concern is then at the agency level, under a Public Information Act request, information that would otherwise be confidential has now become public.
Referenced. Information that was previously protected could be referenced indirectly.
That's the nature of the information, I'm with you. But that referenced information could become public.
No, I'm just saying that background report now makes reference to some information that probably should not be in the public domain. And would not be in the public domain except for some reference to it. And it doesn't mean that makes it public. I'm just saying now somebody might know something that probably should never have known because it is restricted, confidential, or whatever.
Right. The only thing that I would offer there is certainly at the agency level, and I'll tell you our approach here is everything that can be withheld under the Public Information Act, both whether it's under exception, confidential, common law, whatever the case is, local counsel has to be up on those categories of information. Absolutely.
And again, I'm just saying to you, I'm doing a background. I'm simply, my deal is simply a background.
Sure.
That information is not gonna necessarily not exist. And by the way, if I decline him, that person has a right to some information about why it was declined, including his background.
So how much of that, Christy and James, what he's talking about with the background, are you releasing currently on a background investigation for an officer?
Well, I'm not,
The HR department.
I don't know that we've ever had a public
But if you
information
did,
request
what
on
would
one.
you release?
Probably have to release all of it unless there was an exception that we
For
could
the
either
entire
redact.
background investigation, other than like address, you would redact.
Obviously, if it's
Yeah.
something, it depends on what they're asking for in the content within in the file. If it's something, if there's some privacy concerns or something that would impede investigation, your exceptions in the PIA, we're gonna ask for ruling.
But
I think you would do that, you should do that anyway, because there is no law that is, or statute or whatever policy that we can, adopt as a model policy to prevent that. It's really based on the content and the circumstances of the request.
Yeah, and just to Chief's point, like I agree, and I think John knows as well, this is going on a lot at the AG's office. So they are trying to get, I say they, just people. I don't know who they are specifically, but they are trying to get a lot of information about things like backgrounds from cities and their HR, because there's this whole thing about file, internal, external, and it's getting worse. And so, yeah, we need to fix that legislatively, and we've been trying to. But while we're doing this, I just think keeping that in mind, because I don't know how quickly that's gonna happen.
I understand, and certainly the downstream result of doing background, it's like it's always been. There's certainly with the fact scenario you're talking about, more Public Information Act requests for background checks. We don't get it as much here, but I certainly understand that it is going on out there. As Ms. Lewis said, there's a multitude of exceptions you have to raise when you go through these backgrounds. When you're trying to withhold information, there's financial information, there's familial information, there's all kinds of personal information in there that is not relevant to the qualifications of a public employee. Okay, that's kind of the bottom line is there are the qualifications of a public employee and the facts related to their previous employment. That's the heart of it. But there is a ton of other information in there, whether it falls under common law and privacy, whether it falls under a specific exception under the PIA. That's why in response to these things, local counsel needs to know, and HR departments have to be well-versed in the Public Information Act. Absolutely.
And to your concern, and I get it, but I think too, and it's just noted in the act, the ability to protect and withhold information, that still has to be balanced with the needs of the public. The PIA works out the presumption that information is public. So, unless it meets an exception. So, you have to strike that balance too.
And all of these concerns pre-exist 1445.
Correct.
Correct. Nothing.
This is
Yeah, but this could exacerbate
territory.
it though. This could absolutely exacerbate it though, if we
So
do
here's
the wrong
a
thing.
recommendation, just so we can get off. What if we do in red that 6th bullet point in red, so that we can contemplate it for final decision in January? And that way y'all can go back and discuss with your respective agencies whether or not you think the ultimate disposition should be included in the investigative summary, in the summary report.
Or just what those are, maybe.
Yes. So that would be my recommendation to the committee to get us off center. What do y'all think? Y'all want to put it in red, which just means a tentative. So Jessica, if you can make a note that we're going to put that, or you or Iris or whoever is going to do that. Do you need the actual language? Okay. And the dispositions of each allegation of misconduct. All right, just email this to you. I'll do that way. That way we won't use all this time. I'll email this to you.
And if, it's been provided in materials, but if you take it back and you discuss it with legal counsel, city, county, et cetera, I'll give the legal citation for the specific language, regarding disposition of investigative and informational findings. That is section 1701, 4522, small lowercase b, 1, capital D, and section lowercase b, 1, capital F. If that's wrong, I'll blame Aaron Heath.
Okay, Iris, I gave it to you.
John, I hadn't had a clear answer on whether or not collective bargaining agreements are gonna affect this.
This meaning what?
What we're doing here. I mean, I could have a CBA agreement that says, you know, the mayor is a custodian of the file and only he can see it. I'm just wondering if
I defer to the, Jennifer, what are your thoughts on this?
I mean, this actually came up the other day when I was discussing some of our work so far with one of the attorneys, and I do think that it's something that could come up, because there are sometimes collective bargaining agreements where they're basically negotiating with city legal or the mayor, as you typically city legal.
I just use that. I mean, I've got a collective bargaining agreement that specifically outlines disciplinary investigations. It's contract form now.
Sure.
So do we have a clear answer or whether or not this is going to trump?
Yeah, typically it would, like meet and confer would.
What would trump what?
So the meet and confer, the chapter 143, the differences between like a meet and confer contract that's negotiated in 143, we gain a lot that's outside of 143 in those negotiations, and we, you know, those are in place until.
Meet and confer can only contemplate working conditions, hiring conditions, and salaries and such. It doesn't contemplate a statutory provision to send information to TCO. It's very, in 142
Yeah, and I don't think it
143.
ever really would. I mean.
So I don't see how collective bargaining or meet and confer could supersede a requirement to provide information to your licensing committee.
No, I don't think it would contemplate that ever, but I think he might be talking about some of these investigative issues or findings or.
I guess the answer that I would give to that, and I have to speak on behalf of what we have before us in the Sunset Bill, is to any extent that any agreement, to whatever extent 143 or whatever chapter of Texas law allows collective bargaining, we have to, let's take a step back and remember this is for the statewide determination of fitness for duty and hireability for every agency in the state of Texas. I think there's a great deal, obviously, of latitude within collective bargaining, but to the extent that I think it would subvert the purpose of creating fully informed hiring decisions by any chief administrator in the state of Texas, whether they're a civil service city or a non-civil service or whatever the case is. I think to the extent that that type of law does not harmonize with this, I think the overall reach of this is going to control. Yes, to the extent that it would interfere. Now, I think there may be some things at the margins, and without specifics, it's hard for me to answer that as well. But I think as a general proposition, this is going to be kind of the, I would say this is the, this would be the guidepost, and it's the most recently passed too.
Okay. Iris has the language. Are we ready to move on to what should be number 3? Iris, if you'll make a note, investigation is listed as number 2, but since definitions is number 2, it needs to become number 3. And then you all made a recommendation that we redact serious on the first sentence. Is everybody in agreement that we redact serious? Okay, anything else on the now number 3 investigation? Are y'all good with the standalone sentence that's now part of number 3?
The what? I'm sorry.
Which just, that it's listed as number 2, it says investigation. So it would be number 3, investigation.
New number 3.
New number 3, this agency shall investigate allegations of misconduct that may result in suspension, demotion, or termination. That was your intent, right?
Yeah, so I took the rest of it and stuck it in the definition.
Yep.
But didn't want to get rid of the anchor sentence there.
Okay. So now, first of all, are y'all good with that?
Yes.
All right. Moving on to now number 4, summary report.
So we talked about the definition of summary report that I made up. And then this was to explain what to do with that. I got confused because I did not remember why we have the regardless of the disposition findings of the investigation. Can you refresh my memory as to why we included that, or is that now, is it okay now that I struck it since we have now included that other bullet point?
I think one of the mandates that we had was that a mere allegation of untruthfulness. So that would probably speak back to leaving that.
Even unsustained allegations
Have to be reported.
will be a summary report that will be submitted to TICO.
That made me a little bit nervous after I slept on it
agreed.
because,
Yeah, it made me nervous first time I got here.
yeah.
I understand the concerns. We need to probably take a look at the statute because I do believe that it requires all reports, unsustained or sustained, ultimately to end up in the confidential database for use for the next agency. And we can go back and we can look at those if we need to.
Okay, I just didn't remember why we had it. I assumed there was a reason, but I could not remember, so I took it out.
And I'll go through the provisions, so it's just not me saying it because.
I believe you, like I said, I just don't.
Let me, Jennifer, let me go through some of the language. All investigations must be completed and reported in a timely manner, and I'll give the citations here in a minute. Law enforcement agency submits to TICO each report of a complete investigation. We also have, I had it written down here, pardon, got a lap full of papers now.
John, can I ask something before you go further on this?
Sure.
So I agree with what you're saying right now, but it doesn't say all investigations. I mean, that is in the chapter that talks about misconduct investigations. And misconduct investigations are defined as sustained matters. So I'm just wondering, this whole question about everything being reported, I know what you all are thinking. I'm just saying, we keep beating around what misconduct begins. This whole piece of law begins with defining misconduct as one of two things: a violation of law or a sustained matter that results in a suspension, demotion, or termination. So here, it's up before to say investigations only. And I'm just saying it isn't investigations only. It says misconduct investigations, and misconduct is defined.
I think misconduct investigations are not based off misconduct, they're based off allegations of misconduct. If you receive an allegation, which is different than misconduct.
I'm just going by the statute.
I understand, but the word misconduct.
Not you, I'm going by the statute.
Which section?
He's going to the definition at the start of 1445.
Okay, so if we can go to 4522B1D also supports complete an administrative investigation of alleged misconduct and prepare and submit to the commission a summary report on the investigation. Complete an administrative investigation of alleged misconduct. That doesn't say sustained, that says alleged. And prepare and submit to the commission a summary report on the investigation, including the disposition of the investigation and any informational findings in a format prescribed by the commission in a timely manner, but not later than 30th day
And what
after
is
the date.
misconduct?
It's the definition in the model.
But again, going back to the intent, which was originally in those meetings was upon separation only. So again, my concern is, if we're opening this up to anybody can put this in any time, why would you, we can't do that because otherwise everything's available in secure share anyway. So like we've already said, if that's the case, why would we be putting unsustained misconduct or giving them the ability to do that whenever they want, it should only be, if we're gonna include unsustained, it should only be upon separation. That was the intent of the legislation.
Well, that's what y'all have done though in the model
Well, no,
policy.
we've given them the ability to submit it anytime they want, which
Yeah.
means, again, it's in some kind of misconduct database, which is what we're calling this, when we could just get whatever information they need through Secure Share. If that's what they intend to do, is hire someone who's already working for currently working for an agency.
I agree with you. Looking back, as I remember I was a big part of that conversation, because I can send it pretty much right when we're done. But in retrospect, I'm more leaning towards getting that out of there and just doing it upon the 30 days after separation to send the file, the complete file. I think that alleviates some of what Chief is talking about, this information being out there. Because if we do it after separation, then you can either go through here and get the file itself, or you can go to the agency and get basically the information is going to mirror each other. It's going to be the same stuff.
Which is the intent of
Right,
it.
which
It's
is-
not because like an HPD officer that's been there for 30 years, there could be a lot of allegations of serious misconduct that occurred in their 30-year career. And if at some point they ever wanted to go somewhere else, again, and let's just say Houston decided to just start sending it as they occur, that's all in there. You know, and if they're still rightfully employed there and they're trying to get another job, there's gonna be this stash of misconduct that was reported to TCOL over 30 years. That, again, I just think I know that the intent was upon separation. This was supposed to replace the F5. And, you know, I think we've gone beyond that by opening up this database that you can put into anytime you see fit or whatever makes sense for your agency, when that's not really what it was intended for.
So we're saying, and I understand the argument, but I want to make sure that we're clear. We're two separate issues in my mind. When this thing gets submitted and what gets submitted. Let's go back to the what gets submitted. Do we
That's
agree
only- that's been the
everything,
problem.
correct?
Upon my interpretation is upon separation, everything you've got goes.
Okay.
Because the other issues then aren't in play.
No, I
If it's
understand,
only
I understand
upon
that. I
separation.
just want to make sure we are hearing the will of the committee on the first part first, so we're all absolutely clear.
Yeah, to me, the only difference is, as of today, if I'm conducting an investigation, I see it now, I see everything anyway. So if I go to 143 city, I both see A and G. The difference is now it will be here in their repository 30 days after separation. And there's still some records retention on the part of the city, so you still can go look at the file because you have to maintain that for a certain amount of time. So they should just mirror. I mean, so if there was a question to begin with, and again, understand if you're West Texas, you're not gonna come to Houston PD to conduct a background investigation, that's the purpose behind DSS, but you still could. I mean, we're a small agency, we still go, doesn't matter where it's at in the state of Texas, we put our eyes on it. So I absolutely agree with you, I think it should be just the 30 days after separation.
What if an agency wants to submit it in a timely manner versus within the 30 days? Are they prohibited from doing so?
I would
Surely
say
not.
yes, because then it's there. And again, if it's because we've opened this up to allegations, that's been the problem we've been contemplating really since day one, is that they work hand in hand. So if you want to define it and open it up to everything, then you're looking over here now at when it comes in, and that's the problem. If you tighten up the definition, then you can let it come in. But if you're gonna make this broad definition, then it should only be upon separation. They work hand in hand.
The issue I have with that, again, speaking on the little guy, is if you have an election and you have a constable or a chief or a sheriff that gets, for a small county, and that sheriff's no longer there, but there was an allegation of misconduct under his, time there, and then he's beat, but you still have the same officer that committed that misconduct. New sheriff comes in, he doesn't have any idea about what happened.
So are you saying that they destroy all the files when the new sheriff comes in?
I'm saying.
I mean, again, I don't think it's TCOL's job to police corrupt counties in Texas. Like, that's not.
And cities.
You would probably be surprised.
I probably would be, but again, I think that's
These buildings can
outside of
probably
the purview of the TCOL and what they're.
And I understand certainly, if that does happen, probably at the extreme ends of the tail here. but there is certainly a consideration for elected offices, agencies, where there are going to be records turnover, things of that nature, as a practical matter, just simply administrative changing of hands. What happens in those cases? Is that better served with the timely manner being whenever that agency deems what's best for them, or only
Well, would
30
there be
days?
a way for TCOL to withhold that in a separate location until there's a separation that occurs?
Withhold.
Meaning, I don't know, we don't know what the database is gonna look like. That's another problem with a lot of the
But the
discussions
officer's
we're
still gotta get a release of information, so that officer's sending a release of information, so they know that that information is gonna be out there, so they're gonna get the release either from the agency or TCO, either way, they're gonna get it.
And if you don't give it, you're holding them up from getting hired down the road.
Yeah.
So
He knows it's out there,
That's
he's
right.
the one who's giving the release that have you access it anyway.
But these are for people who are still employed within agencies.
I understand, but that officer gave the release for you to get that information.
We're
He's still
operating
employed, but
something
he's
that
wanting
information
you to get to it.
exists, which is what to my point was, if we mandate that these, again, smaller agencies conduct these investigations, but we don't tell them when they have to turn it in or submit it. You have a chief administrator turnover, you have a sheriff or a constable reelected or whatever. Your officer could be a bad guy. He could be a bad officer. That administrators chose not to conduct that investigation. The conduct still happened. Whatever the allegation is, either it did or it didn't happen. If we don't have something in place to where somebody gets that information fairly timely, then we could be negating this entire process, because we have an officer did something that was, contrary to what we're trying to catch, and nobody ever knows about it because you had an administrator turnover.
But I don't think that having an administrator turnover means that that personnel files disappear into thin air and now you're starting all over. That's just not, like I said, there
let me give
could
an
be a
example.
county like that, but that's a much deeper problem than.
Let me give you an example. When I was with the state, I did a background investigation, went to the department. When I get there, the chief's office had FBI crime scene tape on the office door. And I'm like, I'm here to do a background on this guy. And the new chief is like, well, I guess we'll cut the tape. Cuts the crime scene tape, goes in there and looks, there's nothing in there. There's zero in the personnel file. Well, it must be the mayor's office. Okay, so I go to the mayor's office. Mayor's office says, do you have your forms, whatever? I show them the forms as far as, the release deal. She goes, oh, let me check back here. So she goes around the corner. I hear a shredder start up. Zip, 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 zip. The only thing is personnel files is one copy of this pay stub, this first check. That was it. So that's all I had to report back. There was absolutely nothing there. Now, that's the exception to the rule. But with these mid-sized agencies, unless we have some teeth to make them do what we're trying to catch, you're going to have those officers that are going to be, engaging in this stuff that we're going to miss.
I just want to point out that y'all are relitigating what you already decided on November 6th. So I want to reground you on what you had discussed as a committee and finalize. A summary report of an investigation of misconduct, regardless of the disposition or findings of the investigation, shall be submitted to TCO within 30 days of separation of the employee, period. The agency shall notify TCO if the matter is under appeal. The agency shall notify TCO of the disposition of an appeal within 30 days of receipt of the decision. Then you all added, an agency may elect to submit such summary reports routinely after the completion of an investigation. And Jim even said that's very important. He was arguing the opposite side that he's arguing today, because they only retain employee files for 5 years.
That hasn't changed. The discussion that's going on doesn't change that. The issue comes up when he says everything that's investigated has to be.
No, we're now talking about the 30 days.
Yeah. No, but this discussion about 30 days began as a result of when you began to say that every investigation.
And we discussed that from jump as well.
So
regardless of the disposition findings of the investigation, that's what we agreed to November 6th. This is not new today, folks. We already contemplated this, because it says that investigations of allegations shall be submitted.
I know,
We don't give a choice.
I know that, and the discussion is arguing, I think, the same thing, trying to maintain the same thing. But the discussion came up about when we said that we must complete every investigation in a timely manner and report. That's when this whole discussion, what if it's not sustained matters? Are those gonna go in a timely manner? And that's what gave rise to the discussion now, today. I think if we're settled back to only sustained matters and then everything else after 30 days, I think that's the argument that's being, or at least people are trying to make here, I think.
Yeah, I mean,
That's
I realized we went back and forth that even on Jessica's summary here, she has sustained. So I think there's been some confusion between those two categories of sustained, unsustained, and then upon separation or whenever you want.
We don't really have discretion on whether or not it's sustained or not sustained. We have to submit regardless if it's sustained. So let's assume that's our starting point. Are you all now saying, contrary to what you said on November 6th, that you only want it to be 30 days after separation? Did that somehow illuminate
I've
a new
always
fact?
said that. I've never said
I agree with you there.
yeah, I've always said upon separation. That was the
Jennifer's been very
intent.
consistent.
Very, yeah.
Having said that, though, many of you also spoke on behalf of smaller agencies and said, you even said, you're flip-flopping on me now, that, hey, we believe that the agency should have the discretion to submit in a more timely manner.
I like that flexibility because I go back to, the only way you're getting that is if the officer who that file, that document's about, is the one who's sent it to request it. So that's the only reason you're getting access to it is because Officer Smith is allowing you to reach into that. So I think if that agency is better for him that agency to give it as the investigation happens, I think they need to have that flexibility that we put in there.
Go ahead, TJ.
Things that go along with that. One is there's always the concern about this one officer who gets lots and lots of complaints that aren't sustained and how that'll be viewed. And I think chief administrators all know how to view that and weigh that appropriately. The goal in all this is for chief administrators to make informed decisions. The problem that I'm hearing more and more are officers who are exonerated or unfounded, and they want that to be disclosed, and sometimes that's not being disclosed. If you exonerated me in a shooting and the DA doesn't have the courage to present it to a grand jury, I want that information to be made available. That's why I'm signing the release. So don't forget that group of the officers who've had very honorable careers, who've had one or two, particularly if it's a serious allegation of misconduct and they were exonerated, that record should be produced and made available. But then the last thing along your lines is exactly what he was talking about. It's not just sheriffs and constables. What's the average lifespan of a major metropolitan chief of police? 3 to 5 years?
Yeah.
Right. So at the end of my 20 years, if those files are available or not available and why they aren't available goes back 6 chiefs that aren't going to speak up for me. Right? And why is there a problem with my file? If the city puts in place a real process of accountability, they're probably going to do it as they go through those investigations to make sure they're done, rather than hoping at the end of 25 years that all the files are there that are supposed to be there. So I don't know why you would take away that authority from the city. That's what we're trying to do in all this is give chief administrators the ability to make well-informed decisions and give those governing agencies or governing entities the ability to report information and stay within compliance with the law.
Well said. And I'll point out, Jennifer, it says an agency may elect. So your agency may not elect to do this. But others, because of what Jason said, I know I would do it in a more timely manner.
Certainly an element of local control with the flexibility.
So going back to summary report, A needs to say a summary report of an investigation of misconduct, take out the serious, and strike with sustained misconduct, because we don't have a choice on that. 1445 was clear. Regardless of the disposition findings of the investigation, shall be submitted to TCOL no later than 30 days after separation of the employee. That's a standalone sentence. Would y'all agree with me on A?
Yes.
We'll get to the election in just a minute. I don't know if it's further down or not. B, Jessica, I don't know why you put agency. Tell me.
I don't know why I did either.
What?
It should say an investigation shall not be considered complete until all appeals are final.
Agency shall notify. Okay, so Iris, just say an investigation shall not be considered complete until all appeals are final. The agency shall notify TCOL if the matter is under appeal. The agency shall notify TCOL of the disposition of an appeal within 30 days of receipt of the decision. Y'all already agreed to all of that on November 6th. Any concerns? All right. John, John, can you go to the next page? An agency may elect to submit such summary reports upon completion of investigation. May elect. Jennifer, you okay with that?
Already said.
Should I ask?
I will say though, I understand we can't say sustained or we don't have any say in that, but what we did have a say in is I think the important part, which was what is misconduct. And so that's where, again, this opens it up. So I think the important part for the agencies, or the more complicated part for the agencies, is we've opened it up for excessive force, untruthfulness, unlawful if you read through these, we started out with egregious misconduct, and I would agree most of these fit that to an extent. But then again, if you look at excessive force, untruthfulness, and these are just allegations of such, we kind of have gotten away from egregious misconduct. So I think that, again, that's where I'm coming from with the whole.
But to TJ's point earlier, if the officer is exonerated, why in the world don't I want that on record?
No, I agree. I think it's the number. So when the agency gets this policy, it's not every investigation they do that they're gonna have to turn over. It's only these kinds. And again, excessive force, like this covers a lot of the investigations, even though we wouldn't say a lot of them are egregious. Like, okay, so for example, the most common one, it hurt when they handcuffed me. Okay, technically that's gonna go under this. And that's a lot. That's the thing. I feel like we've opened it up, and I'm just making this point because I realize we don't have a choice on sustained, unsustained, but that's why we were trying to really narrow the scope of what misconduct was. And I think we just, in my opinion, got kind of broad with it.
I agree with that. I think a matter is, if it's sustained and you discipline, I don't care what the nature of the conduct is. If it's excessive use of force, but if you're going to tell me now, every excessive use of force, every arrest we make at McAllen is subject to someone saying, you know what, he put on the handcuffs too tight, or he pushed me in the car too hard. So now we're gonna get into what I say, that's not excessive force. TCOL says that's excessive force, you should have done this and therefore you didn't, and I'm gonna file this charge against you, or we're not in compliance, or what. It's just when you start carving out special things like this, it's endless.
But given your hypothetical, Victor, if there's an allegation that he pushed me into the car, and you all do your investigation like you're already doing, and you don't sustain, you exonerate, and you give that document to TCOL 30 days after separation, okay, what just changed about your business model? Nothing.
The only thing that changed is they're having to report a large number of things they didn't have to before. That's it. The information's already there for the prospective agency today, right now. So again, we're just adding another level of bureaucracy for the agencies, that it's kind of like for stuff like that, like Chief's pointing out, is it really necessary?
So your recommendation would be to strike use of force as misconduct?
I understand that excessive force in some cases could be what we said egregious, right? But probably in a very small percentage of them.
Okay, well then better define the small percentage.
I don't know. I mean, I think that would have to be contemplated by the committee. I'm just saying that we've opened it up to a large number of investigations that don't fit egregious, which was more the intent of the legislation, which is why it was sustained and unsustained that they wanted to come in, because it was egregious misconduct.
Any conduct that results in a demotion, suspension, termination, it doesn't matter what it is, it's reportable. But if you're telling me now on truthfulness, how many people are gonna walk in here and that's not true exactly how it happened? You know, I opened a door, she opened a door. The officer says he came in, no, he didn't come in, he forced himself. You know, any allegation of truthfulness, I'm gonna be doing these forever.
We aren't telling you that. The state law says that.
No. The state law is very clear about what misconduct is. Here, we have gone way beyond misconduct definition of the state definition of misconduct under Senate 1445.
No, what he's saying is a
Reread
new
the law
statute.
real quick, because it even specifically says allegations of untruthfulness.
It doesn't say allegations. Any of the following that have been sustained by a law enforcement agency, sustained violation of a law enforcement agency policy for which the individual is suspended, demoted, or terminated. That is the misconduct definition they're giving us. If you take care of anything else that doesn't result in that, it's not covered by this.
I think one point to mention though is that definition that you're reading is in 17.0001, the definition section for the entire occupations code. We are limiting our definition just to the policy for this. So I don't think
But there is a nexus between misconduct all the way through 1445. You're saying misconduct here in 1445 is one thing, and the misconduct over here in the model policy, well, that's a whole different thing, is what we say it is. And that is a stretch as far as I'm concerned. But nonetheless, I understand.
I don't think we have an option but to stretch, if that's what you're saying, because we have to follow this, which is 17010012A, which is an allegation of untruthfulness against license. I mean, that, as much paperwork as that's gonna be for everybody, kind of stuck. That's what the legislature said, that's what they want.
If the legislature said, if we were doing what the legislature said, we wouldn't have been sitting here for 3 meetings going around in circles.
But the legislature also asked us to come up with a model policy. So that's
Yes.
why we're here.
Yes. I agree with that.
Okay, so Jennifer, I'm gonna put this back on you. If you think that use of force is too nondescript, then come back with a recommendation in January.
Okay,
Otherwise-
they try to do that for untruthfulness as well.
Okay, perfect. All right, does anybody have any issues with D? D. David says, if an officer leaves during the pendency of an investigation of, let's strike serious iris misconduct, a summary report shall be furnished to TCO regardless of the findings. To me, that's a little redundant because you have to do it regardless, but I think you're probably just making a point.
Yes, and it didn't feel redundant at the time, but now it does.
But it's really like an exclamation statement. Hey, regardless if they leave, you're still gonna do it, which actually was the catalyst for why we had this bill passed.
I think in fairness, that is, it said, it may feel redundant, but it's also redundant because it's in the statute again as well. So I think that's an important point.
It says that.
I think it's important to have it.
It's really important to remember that these policies will guide agencies that aren't always familiar with or haven't read the statute like we have. And having the reminder lined out in there is critically important to make sure that that's.
That was Jessica's intent, right?
That's it, right?
Okay.
Emphasis.
We're now gonna go to the new letter 6, which is currently number 5, notice of negative letter. John, if you could scroll up just a tad. If a negative letter, memorandum, document, or other notation of negative impact is included in a license holder's personnel file, the agency head or the head's designee shall, not later than the 30th day after the date of the inclusion, notify the affected license holder by certified mail, personal delivery, or electronically. Christy, this one was yours. Did you have any suggested edits?
On B and C, I just added, I think one of the concerns the last meeting was having confirmation that the notice was received by the license holder, so I included that once it was sent electronically, or notice is considered to be received electronically by the license holder, provided it is sent to the department or personal email address listed in the license holder's file and the license holder confirms receipt. And then the last provision, C, if confirmation of receipt is not provided by the license holder within 3 days of being sent electronically, then the agency should send it by certified mail.
The only one that gives me pause on that one is, like in Abilene, our patrol schedule was you were 4 on, 3 off. They're not checking their emails in 3 days, so I'm not gonna get confirmation until the 4th day. So I think we need to differentiate business days versus calendar days, work days, however you wanna say it, but.
Can we change it to 7 days or 10 days?
I would be really supportive of 7 days.
I just came up with 3 days.
Business days.
I'm good with that.
Or even 7 days, because it will give me plenty of
7 business
time.
days. Is it 7 business days?
I think we're.
Yeah, well, then you drop it in the mail.
I think there's 7.
Calendar days.
7 working days.
You want 7 calendar days?
It's whatever, up to y'all, that's.
All right,
I'm good with that.
there's a motion on the floor to change within 3 days to within 7 calendar days of being sent electronically.
7 business days. Businesses, that's the way business is done.
You want business?
7 business days.
I'm gonna say 7 working days for the individual, because 7 working days for every individual is different. It's possible some can be aware of military leave, extended leave, or other kinds of leave, vacation leave or otherwise. It's on the employee himself, and when he's come back to work, that's his first working day, second working day, third working day. So I would say 7 working days pertinent to each individual, but that's just mine.
I would prefer not that the agency would have to look at someone's calendar and all of this. If we've hit the 7-day mark, regardless of why they haven't acknowledged it, it's drop certified mail. That way we make sure they receive it.
Because Christie was trying to save us some cost. This is just kind of a cost saving measure. I agree with TJ. If they don't, you hear nothing in 7 days, just move on and pop it in the
Drop
mail.
in the mail.
This is just the threshold for sending out a certified.
James, but
Yeah,
want to hear your
no,
motion?
no, that's fine. I mean, we send everything out certified, so.
Oh, okay, okay.
In Dallas, so.
All right, so Iris, if you'll reflect, if confirmation of receipt is not provided by the license holder within 7 days of being sent electronically. No, sorry, 7 calendar days of being sent electronically, the agency head or the head's designee must send the notification by certified mail.
Good.
Good. All right. John, go ahead and scroll, please. That's it? Oh, that's one. All right, now we need to jump into a different policy before lunch gets here.
Chief, there was a provision where if there's a negative letter in your file, you have 30 days to give a response. Is that something we would
Oh,
put
yeah, we
on,
might need to put that in there.
on this policy, or would it go in the personnel file policy?
It needs to be in both. I would have to hazard a guess. Since it's not in this.
But this is the misconduct allegations model policy, maybe this is not the appropriate spot for notice of negative letters to begin with. Maybe it all just goes.
In the personnel file? No. Yeah, we can do that.
That's a good idea. So your recommendation is to redact fully notice of negative letter and put it in personnel files?
I think that makes more sense.
James?
Yeah, I think I can.
Carlos, Jason, Christie, what do y'all think?
Because it wouldn't go in a misconduct
Okay.
investigation necessarily, right?
It's not limited to misconduct.
That's right.
All right, Iris, we're gonna fully redact that whole last section, notice of negative letter, and we'll carry it over into the personnel files. So I think it's already there, because TJ did that, but,
Letter A.
yeah, numbers 5, A through C. We'll redact that and move it to the other sample policy. All right, TJ, this one's yours, right, sir?
Yes, sir.
Fire away.
So I just included the changes that we discussed last time. I know we had a little bit of discussion about which PHS and the TCOL PHS and all of this. And then I thought if y'all are good with it, we'll just say applicants for employment must submit a completed PHS. And there's already administrative rules saying you're supposed to use the TCOL one. Whether you do that or not, I guess that is between your agency and TCOL. But so if there's any comments about that.
And maybe we could put the citation, the rule citation in there. We'll
Yes.
get that, we'll get that and follow up with
Okay.
you.
Thank you. Then we discussed the medical and drug screening, separating that out with the telecommunicators. So I just said that under A, everyone has to have the drug screening, and then the medical exam would only apply to peace officers and county jailers.
Where are you at? What section?
I'm
Number
sorry,
six.
number 6.
So scroll down.
I'm just covering the changes that were made.
All right, now we're here. Keep going.
Yep, so under 6, so just clarifying that A applies to everyone for the drug screening. B, dealing with the medical, deals with peace officers and county jailers only. Under 7, we discussed clarifying that the psychologist or psychiatrist has to be licensed by the Texas Board of Examiners of Psychologists. So I added that in there.
Did you all, we contemplated this on November 6th, the notion that it's a best practice, could TJ reinforce this, that even if there's less of a 180-day break-in service, we still do a new psych and medical. Did you contemplate that?
I think we're getting some info from the other committee, if that was something they were working on.
I think that's right, since that's what they were. That was their
They are
scope.
working on that.
They are?
Yes.
Okay, good. All right, sorry, TJ. Go ahead.
No, it's fine. But as it reads here, it basically just says everyone will have to do it. I didn't put the caveat of the 180 days on here, but we can get feedback from the other committees.
Iris, make a note that Texas Board needs to be corrected in spelling. This is 7A, licensed by the Texas Board.
CJ, or psychiatrists who are doctors, MDs, fall under the examiners of psychologists?
Yeah, there's a separate one.
I think psychiatrists or MDs are different from psychologists.
Correct.
So.
So are you
You
saying,
need to include, probably Texas medicals, for psychiatrists, they're gonna fall under medical doctors. So their licensing board is gonna be the, TMA?
The psychiatrist would be the Texas Medical Board.
I think I took the language from the TAB from TCOL, but I'll go back and clarify that. I'll verify that.
Because I think they're board certified in psychiatry, which is specialty, so they're gonna, I just don't wanna miss that.
Yep, you're right.
Okay, anything else on 7? Moving to 8, fingerprint check return.
So we discussed this one. I added before being appointed, and I want to discuss the word appointed. Each applicant must successfully complete a fingerprint search of local, state, and U.S. national records and fingerprint files to disclose any criminal record. A copy of the fingerprint check return shall be maintained in the personnel files. I think I got that language from SB 24, I believe. But I put appointed instead of hired. Because we typically do that on the first day of someone's employment with our department, so it's not as a part of the background investigation. So if everyone's good with the word appointed, you do that before the L1 is actually.
It actually helps, so like my agency may hire you, put you in a nondescript role before you ever go to the academy. So it's a long time between hire and appointment. So that actually helps me.
Yeah, I like that change too.
Jessica, does Houston do that?
We do yeah.
We don't. We do 10 prints and you don't get a step in the door until you're asked.
And that's fine that'd be more restrictive, so. Then we added in the firearms qualification, so if you're a current Texas peace officer, you have to submit a record of annual firearms qualification past 12 months. Just added a point here about completing the L1 or L1T as we discussed last time, and then included the provisional hiring period that the legislature basically mandated we have to include here. So applicants will initially be hired on a provisional basis of 45 days. I think the statute says minimum of 45, but I put 45. We can discuss it if we want. And then employment of the provisional employee may be terminated if information relating to an allegation of alleged misconduct by the provisional employee is received from the Texas Commission on Law Enforcement during the provisional period.
So I'm curious, what's the process, TJ? So if I'm looking at hiring Jessica, she comes on board, and then she's maybe in my mini academy, and then it's that former agency then submits all of that. Are y'all gonna now notify us, say, hey, by the way, we have new documents uploaded? How am I gonna be notified that there may be additional concerns about Jessica?
I think that is one of the reasons why some form of misconduct report might be good for us to know about, because it can trigger notifications if there's pending if there's been like a request made or something like that for a background investigation.
Electronically,
Yes,
electronic notification.
yeah.
It's going to be really challenging, in part because you don't have to separate from your prior agency. They could keep you appointed and then they could avoid the reporting requirement. You can have dual appointments. So I think that there's gonna have to be a responsibility for the agency to make a second inquiry preceding the end of the probationary period to make sure that there's no new records that they failed to consider. I think that's gonna, in the short term, gonna be the requirement.
Do it twice.
Yeah, but you've already, okay, you've already requested the information on an officer. I'm already looking at Jessica's background. So I'm gonna see if she's gonna come over to my department. Well, we're not talking about it.
He's asking me if he hires Jessica at the end of the 45 days, how does he make sure that there's no new records? And I think you're gonna ask, are there any new records? And if there are, then you consider them, weigh them appropriately and make the decision. But I don't know that they're gonna be required this is based on the assumption that everyone who starts at a new agency separates from the old agency and separates prior to appointment with the new agency, and that just doesn't happen. I'm telling you, that doesn't happen.
I think when we discuss how the separations are gonna work, that there be some form of indicator on that separation form that there is some sort of appeal underway or a pending investigation, and then that would be the indicator of in 45 days, there needs to be some form of communication.
And it's my recollection that that's why we included that in the legislation, was because this was to capture those who might resign before the investigation is done. And then this allowed us to go to catch.
That's what would make sense.
Egregious misconduct specifically was cited.
And the bill obligates us to says the commission shall notify a law enforcement agency seeking to appoint a license holder of a completed investigation report submitted to the commission with respect to the license holder not later than the 5th business day after the date the commission receives. And I think what you're looking at with the 30-day window reporting in, that's when, the extra 15 days is us turning that around to someone who's expressed it, either appointed outright or expressed an interest to appoint. So I think.
About seeking appointment, not post appointment.
Does that match up?
So the other TJ, if the law says a minimum of 45 days, I'd rather have it minimal so that my agency could do longer than 45 versus what you have codified. I get 45.
Sure, yeah, we can put minimum and then if the agency wants to do 60 days or 90 days.
I would prefer more discretion per agency.
Well,
Gotta be an end to it sometime.
Yes,
Yeah,
yes,
you
yes.
gotta put an end to it. So if you're gonna say minimum 45 to, I don't know if you're 90, whatever, you pick a number, but you gotta have it down.
a maximum for sure.
Yeah.
I would need a trigger.
Yeah, I mean, I don't care, 90, that's something.
I think going over 45 is a good idea as well.
And you could trigger the 45 days off the separation from another agency too, so that if you seek dual appointment, that you're probationary throughout that dual appointment. There's a possibility of misconduct at the other agency. It's triggered by your separation date, starts your 45 days. That solves part of your problem. Makes it really complicated and confusing. Solves your problem.
Well, I think it's covered under probationary period for those that have them. And I guess it's for somewhat smaller ages, but like for 143, whether you're 12-month or 18, depending on appointment, going to the academy. I think ours is already set in place to probationary, because you gathered that information, you'd be gone. Whether it was it could be 6 months later.
Sure. What's the standard probationary period? Just
12 months and then 18 if you
good
bit
bit
the
then.
academy.
Yeah, good bit.
Okay, so go ahead, teacher.
I noticed a couple unrelated things that I wanted to bring up in the other sections.
Before we leave this, do y'all want to leave it as written or do you want a minimum of 45 days?
The legislation contemplates at least 45 days.
So I say at least 45 days.
I'm good with that. I would be more comfortable if we say minimum 45 and maximum 90, or just some definitive time and not an agency says it's gonna be 3 years or something.
I would say 45 and 60. I don't think I'd go 90. Because, I mean, if they give shit, they're gonna get it out there quicker. And, you know, the longer you drag that on, that officer sitting there going,
I think you'd want 90. 90 is a benefit to admin, but if you want it at 60, that's fine.
Admin lost 90.
Yeah, I was gonna say, I'm sure admin's like 90.
I agree with James on that one.
180.
All right, so we agree on minimum of 45 days. Do you want a cap or not? To me, the cap is irrelevant because I'm gonna have a probationary period that's gonna
There needs to
supersede
be a
yours.
cap, because there's, not everyone has,
You said there should be?
yes.
All right, so 60 or 90?
Go for 90.
90? Spoken like an administrator.
90.
Oh, wow, labor says 90?
I mean, most of our,
Me
like
too, though.
they said, 12 months, 15
Yeah.
months, 18 months is the standard,
Ours
so
is 18
I
months,
mean,
so-
90 is actually pretty good.
So minimum 45 days, maximum of 90. You okay with that? Jason, I know you wanted less, but could you live with 90?
Got it.
All right, TJ, you got it? Irish, you got it?
So you're requiring hiring not less than 45 days. And that's just what it said. When you say it must be 45 days, so if I want to get rid of him at 30 days, what?
Yes, you can fire him at 1 day.
Ahead of time.
minimum of 40.
Minimum.
Okay, I'm just saying.
Yeah.
To be initially hired, this is for 45 days.
No, it just says a minimum of 45. So day one, if you learn Jessica has a really deep closet with lots of skeletons, we can fire
I don't know about hiring
Yes.
Jessica anymore.
Shady character, I'm telling you.
her. All right, looking at B-boy. TJ, pick it up from there.
Employment of the provisional employee may be terminated if information relating to an allegation of alleged misconduct by the provisional employee is received from the Texas Commission on Law Enforcement during the provisional period. I think I got that language from the bill, but I'd be open to cleaning it up a little bit to something like sustained or.
If it's, they're exonerated.
Yeah, I would add the word sustained out.
I thought they're supposed to consider the misconduct investigation. That's what they're gonna get, right? They can weigh that however they want. I don't think we wanna tell the chiefs how to weigh that. It's the
I would like the discretion.
So it's not, they shouldn't be weighing the allegation. They should be weighing the information in the misconduct investigation.
Yes, that's relating to an investigation.
I think what we're saying is, TJ, we're fine with the house written. Right?
You don't wanna change allegation of alleged to investigation of alleged?
Yes, I think that's
It-
better.
yes.
Investigation.
Oh, that's, oh, yeah, because it's
Investigation.
repetitive. Yeah, yeah. All right, so Iris, it would say information relating to an investigation of alleged misconduct. All right, keep going, John, scroll.
Can I hit,
Oh, wow, what time is it, 11:42?
can I hit a couple minor things? On number
Yes.
9, when you talk about qualification for the last 12 months, there could be an officer who's been unappointed for the last 5 years but kept his license active and is eligible for appointment. Are you trying to require them to go qualify somewhere, or do you just want within the last 12 months of appointment?
I want to do whatever y'all are currently requiring. But if someone's not appointed, they're not a current Texas peace officer.
Right, they should be qualified upon, a lot of agencies have it as part of their onboarding process before appointment. That's preferable.
Well, and that's what we do, but then we were told we need to get the qual from the previous department.
Some agencies do that, and that's acceptable, but that's not, if you're going to have them shoot your course before you appoint them, then that covers everything. There's no reason to go to another agency and get their previous qualification. What it is a lot of times the small agencies, I don't even have a firearms instructor. You happen to have a qualification that's within the 12-month period. I get that from your previous employer. I appoint you using that as evidence of your qualification. It is preferable that the appointing agency make sure that person's qualified to whatever standard the appointing agency uses.
So then you should remove must, right? Submit.
Well, put or complete qualification with the agency prior to appointment. I think if you do
Okay,
that, they'll
Mr. Nolan.
recognize the possibility. I think it just gives them both avenues.
Yeah.
Or you can do, or complete a firearms qualification before appointment.
Prior to appointment.
Prior to appointment.
Yeah, but then I could go. I would think in the best interest and liability for any city, you would want your officer to pass your qualification course.
Again, what we have to deal with are the 1, 2, and 3-man agencies that don't have those resources available. And that becomes a stumbling block to someone that I need because I have no one to cover shifts tonight.
Okay,
And
all
they
right.
want to use the prior one. So we try to give them another avenue. We'll make it clear the better one, and most agencies use that. But we don't want to stop people because they have to drive 60 miles to be able to use it. If you scroll back up in number, I think it was 7, when you're talking about the L3. In E there where it talks about shall physically sign the L3 form. I think we would like for that to become someday maybe an online process where we might do digital signatures. So I think just removing the word physically leaves open that possibility. That's the way it's generally done now, but I don't want to restrict ourselves to that.
Anything else on this policy? The other thing I have, the note is to look up the certification for the psychiatrists.
Texas Medical Board.
Texas Medical.
So under adding that, you'd say physical and or digital? You just say or electronic means for signature?
Just say shall sign.
Okay. So can you say just shall sign and?
I take it out physically, it leaves us the ability to do either way.
They have to see, I'm sure the other committee's talking about this, but they have to actually see the applicant, right? They can't do like the new way.
It's being discussed in great detail.
Okay, well, I think that could be the spirit of the physically sign. That you actually met with that individual officer and not.
There's all kinds of problems. I mean,
I'm fine with it, I'm just throwing that out there. I'm curious if that's being.
I would prefer that the agency send it digitally to the doctor and the doctor sends it back and that it's captured by us in the process. So we avoid ones where there's questions to who picked the doctor, whether it was the person being appointed or the agency, and then was that the actual form that was sent with them or not.
Great, anything else on this policy?
Good job.
Thank you.
All right, I think Iris, is lunch here? Okay, so this is a good stopping point. Why don't we take a break and resume at 12:30 under the direction of Chief Anderson. 'Cause I need to bug out.
Do you want to set the date for the next one?
Yes. Thank you for suggesting that. You probably don't want to come back on January 1st or 2nd. So January 8th is a Monday. Please look at your calendars. January 8th, again at 10 a.m. You're going out?
The college football playoffs.
Yeah, that's the championship game in Houston that day.
But you don't need me, I'm just.
Oh, we do need you. Misery loves company. I can do Tuesday the 9th. Can't do Tuesday? Thursday the 7th.
Thursday the 11th.
Sorry, I just jumped back to December from my thing. Thursday the 11th.
I can't. Can we do how about the following, the
15th?
week before,
15th
after?
is-
January 15th?
It's MLK.
Yeah, it's
Holiday.
MLK Day.
Oh, it's a holiday. Everybody's gonna be off. 16th? Is that bad? Oh, you can't do any Tuesday. Oh, gotcha.
Suggest the 10th?
The 10th.
10th.
I can do the 10th.
10th?
Wednesday the 10th. Everybody?
I'm in Miami.
You're in Miami?
45th anniversary. I'm not gonna miss that.
Oh, yeah.
It's a wise choice.
So it's the 10th?
Well, only one absent. Robert can't make it on the 10th. Everybody else, can you do it on the 10th? Staff, can you support the 10th?
We can support the 10th.
All right. So, Robert, I'm sure you will join us by teams because you'll be riveted during your anniversary to be. All right, everybody, January 10th at 10 a.m. All right, so if you'll make note, please. All right, let's take a break.
12:30, you guys ready to start?
Yes.
Okay, reconvening after lunch. A couple people no longer with us, Chief Standridge and it looks like Chief Rodriguez have both departed. We were talking about the hiring procedures, model policy, and thought we wrapped up, but some additional items came up for consideration. TJ, do you want to talk about some of the stuff that you identified?
Just wanted to mention a couple things for discussion. In the background investigation, section 3, letter L talks about information on the person's law enforcement background is available through NDI. So this is a new requirement under statute that everyone check NDI. And it's a little bit confusing to some of the people who've made inquiries. NDI is just a pointer system. It's not based off social security number, fingerprints, it's just a name. So it's entirely possible that you get a return on someone and it's not the person that you're inquiring on. It's also possible that you get returns from another state, but it's just meant for you to then follow up with the agency who entered that person to confirm whether or not it's the same person that you're considering hiring and then what information is available from them. So you might just want to add on to this to make it clear that if they receive a hit through NDI, then they're responsible for following up with the agency that entered that information in the decertification index. Just checking NDI alone is not enough. It just points you to the agency where you have to make the inquiry. And then under section 5, there's a paragraph about background confirmation forms. And by and large, this is where we're seeing the most failures, and particularly the failures that are getting people into trouble. At the end of the process, someone signs off and sends in a form certifying that they've done this. And part of it, some of y'all are gonna laugh, but they put down that they checked files in person, and we find out that they only talked to somebody over the phone. And they're saying, well, yeah, I talked to them in person on the phone. No, the law requires you to obtain and review the files. We have agencies that submit TSS requests, they check all the box for TSS and they turn it in. And some of those agencies don't have files, they don't send them back, they send them back and they don't view them. We're constantly, it's my belief that most of my job is education and communication. That most of these problems, when we educate people, the violations stop. These aren't people who are intentionally trying to get around the rules, they just don't know the rules. And this is an opportunity to make it clear what the rules are, to make it clear how you should complete a background confirmation form. If the agency no longer has the files, how you should mark that. If they do have the files and don't make them available, how you should document that. I think that this could be very useful for a lot of background investigators, and most of the ones we talk to have never been trained, and this is their first time doing a background investigation. If their agency had a policy that would guide them through that process before they submitted that sworn affidavit to TCOL, that would be helpful. I don't mind trying to draft something or work on that. There's nothing wrong with the paragraph that's here. It's just if you're going to give a policy to agencies to adopt, I would want to give them guidance in that area because that's where I'm seeing a lot of failures that are getting people their license suspended or getting them in trouble.
And again, this may provide an opportunity for more uniform understanding of what the requirements are under statute and in accordance with the background confirmation form.
Yeah, but how? I was thinking, big department's not a problem. It's easier. How are you how are you going to get the message out to the 2,400 smaller departments in the state of Texas that this form needs to be adhered to? What do you do to notify and get them alerted of things like this?
That's what I'm saying. This is the policy that they have to adopt, and you can put it in here. This is your opportunity to help guide them through that process.
Yeah, because I think, like you said, and I've talked to you before, but I think a lot of people just don't know what they're supposed to do, or what they need to do. But the information needs to be gotten to.
How it's technically gotten out there, that's certainly something that we've, this goes back to last session and certainly been supplemented this session. The ability for us to, we can on personal email level, on the department email level, on multiple email levels and communication wise, we can spread this out to everybody as we go through the process. Absolutely, just like we did at our Target 100 initiative last fiscal year, which we took our previously looking at 12 to 1,500 reprimands, suspensions, or unfortunately a few cases of revocations due to training noncompliance. We ended up went down to 3 this last year due to the ability to send out these emails.
Which was great, because I was on that list. I got it done like the second to last day.
Fantastic.
But I got
It worked.
Which my department notified me, but it was nice that y'all notified me.
Sure.
Saying your hours, you need to take more hours. And
here's the ones you need. Here are the courses you need to take. Yeah.
And so that did work well.
And I can't do that over and over with background investigators. That's a problem. We can do a big social media push. We can put our newsletter. We can do all this. A year from now, when somebody who just got hired is told to do background, his agency policy may be the only thing he has.
That's right.
And so that's why I'm encouraging you to delineate in that section a little bit more on background confirmation forms to at least give them a fighting chance.
Okay. So TJ, on the BCF, do you want to send me language more specifically on what you'd like to have in there?
Or we might work on that together. But
That's fine.
yeah.
Okay. And then on the NDI, I added at the end of L, and following up with entering agencies if a matching record exists. Is that sufficient, or do we need more explanation on that?
It's 3 says shall include reviewing the following information from NDI. So it already tells them they have to. It says shall include reviewing the following. So I think either adding that or not adding that, you're still.
You don't get information from NDI. They just tell you the agency that has the information.
So they just say, hey, there's a file over here.
There may be a file that
Yeah.
we have received information on a person with this same name, and then it's up to you to contact that agency, find out if it's the same person, and then what information they have related.
Got it. Okay. See, I'm not familiar with that. What did you add?
I added and following up with entering agencies if a matching record exists.
Does that meet what you're after?
Yeah, you might use the same obtaining and reviewing files available from or something rather than following up. I think that's what they.
And
obtaining and reviewing files available from the
What's the
entering
current for
agency.
that? What's the current rule for that?
There's not. This is a new requirement that you check.
And is
in
it
fact-
new that we're putting into this as well, or we've been putting into this? That Texas TCOL has been putting information in there for how long have we been doing that?
I don't know.
Long time?
Yes.
Mm-hmm.
And it's voluntary right now. Some states are, some states are not. It's not. I think there's a move towards there becoming a standardized database. But right now, we selected this one because it's the only one that's available.
And maybe it varies by state, but is this with the post or with the law enforcement agency that we would be following up with?
In the states that I know of, it's the post, but again, it's just a pointer system. It tells you a record's been entered, and then it's up to the investigator to follow up and actually review that record.
Does it give you any information about it gives you, like, you have to determine if you are gonna contact the post or the agency or.
The problem is because this has been building for 15 or 20 years, what they required 20 years ago is very different from what they required a year ago. So depending on what you get, you may or may not have, I can't tell you what
Little
information.
to no information you
Right,
have to
you're
go.
just gonna have to show that I tried to find out if those records exist and reviewed them. In some situations, if you use a common name, you're gonna get multiple returns and probably establish that none of those are the person that you're investigating.
So, and obtaining and reviewing records with entering agencies if a matching record exists. Is that sufficient? Okay.
I think that's the purpose.
And you guys will work on the BCF? Any other comments on the hiring procedures model policy? Let's now switch gears to the personnel file policy draft. Would you mind putting that up on the screen for us, John? Who worked on this one? Was it Stan?
Yeah, I was on it.
Convenient.
There was a hand, was TJ, and you were on it, right?
Yes.
Yeah.
Okay, and I think I ignored some emails about it.
This one?
No, the other one.
That looks like expected.
Perfect.
There you go.
Jameson, do you wanna walk us through it if you don't mind?
Sure, I guess. So this started, and I'll let everybody speak on what they added to it. So Stan came up with this initial policy for us to review to kind of pick apart. I know, we actually just had some discussion. I'm thinking now maybe we should, in the policy part of it, designate that there are going to be two files. I mean, I believe the intent is to make this like 143-089, right? Is that kind of the copy part of this?
That's the thing to me that ties everything together. Right. That's the only thing that can make it all frankly make sense is if you put it there. It's meant 4522 and 4535 out of the new 1701. It reads to certainly duplicate much, if not everything that 143-089 does.
Yeah. Well, and when you go through and you read it and both sides of it, and they talk about I know one of the big things that I pulled out when we were talking about the personnel file, and then there's the I can't remember which section it is under there that talks about anything that's not substantiated or sustained or whatever does not go into the personnel file, but then it just ends. It doesn't say anything. It doesn't say that you have to maintain it. It doesn't say you have to do anything with it. It doesn't even say you have to put it in a file anywhere. So one of the things that I did pick out and I did put in, and I think you covered it down at G, that the agencies that are not 143 that fall under 1701 need to make sure that they maintain that information versus just, I don't know what they do with it, if they maintain it. I asked a couple non-143 cities in my county, and I got varying answers. Some keep it, some of them don't, because it's not true. It's not an allegation. I told them that they're going to have to start keeping that. But I think that was covered down in G. That was one of the big parts that I had made mention in the policy. As you go down the procedures, it pretty much just follows the law itself. And copying 089 to a certain extent. It's 4522. And then there's the section, I think of what's 51. Then there's in the law, it goes from 14, it goes from 714522, and then it references, is it 4535 or something like that?
There's a cross reference or two in there.
There's a cross reference in there that talks about the files themselves and what goes in. I think it breaks it down a little bit further, just like it does in 089 and 143.
You got it.
And so I think there was some mention about maybe making cross-reference to that. But ultimately, at the end of the day, I think one of my comments was, how do we make this as simple as possible to people that don't know what 089 is? And how do we make them understand that they're going to now have a HR file and a whatever you call it file, officer file? And I don't know if we need to put that at the top somewhere. I don't know. I don't know how we make that distinction between the two. It's easy for me because that's what we are.
Sure.
So, committee folks, what else?
Do you have a copy of this, John?
Of this right here?
Yes.
I do.
Okay, so what did you think about G?
Let me look at G. Let me look at it again and read through it here. The agency shall maintain an employee development file. And that's just for the purposes of giving it, we're talking about a non-civil service city.
Yes,
What
exactly.
are we gonna call that?
Right.
That, what, I think is a matter of law. This is just, I'm gonna preface this in what you, I think you brought up a good point. What are we going to call that?
Right.
What for a non-civil service city do you call the equivalent to their G file? Is that what we're talking about here?
Yeah.
Okay. That's a good question. And I know we talked about it at the first meeting, and I know that was getting probably into the weeds, and I know Chief Rodriguez was talking about a little bit today, I think at least alluding to it, the confidentiality of that file. We obviously know under 143.089G, that file is confidential. That confidentiality language is not specific to a non-civil service city covering the same type of information. I think there is a way to bridge the gap until next legislative session there, because obviously if you have an A file and you have information that does not fit into the category of quote unquote personnel files, as a matter of law, you have to have a G file. Whether you want to admit that information, there has to be one. I know civil service law says that you may have a G file, but I think if you have anything that goes outside of fits the criteria, it has to go. It's automatically. It's a matter of law. It's a G file. You have G file information. As a result, it's confidential. I think the same thing applies to non-civil service, or let's just call it 4522 for the sake of the conversation. 4522 G file information. Let's just call it that for shorthand. I know that's kind of a lot of kind of context, but it kind of gets down to exactly what's in subsection G on this policy. How should that information be treated at the department level? How should it be treated when it's sent into TCOL? Obviously, treated the same, I think, with the respect to reporting it for future employment purposes in the confidential database, because there's a specific carve out for G file information. You have to treat this the same. I think the big question here is, how is that treated at the agency level? In non-civil service cities where you don't have a specific confidentiality provision, but I think there is a strong implication for that information to be confidential, obviously, at the agency level. I think for the purposes of both this subsection G here that we're talking about, or section G, you can designate that information for the confidential database, designated. That type of information could be designated for the TCOL confidential database, and you can seek to protect it at the agency level with respect to that. Now, does that have the power of a confidentiality statute or common law or provision? No, it doesn't. However, I think that's the best we have to work with what we have before us, if that makes any sense.
That makes sense.
Go ahead, TJ.
So are you recommending, because if you call it an employee development file, it sounds like there's a purpose for it. You're saying the sole purpose is to fulfill the statutory requirement of contributing the TCOL confidential file. And that makes it, that's as close as you can get to making it confidential, because the only purpose it's used for is fulfilling that requirement.
Correct. Because it's a byproduct of you having, if you have done any investigation into any alleged misconduct, creating whether it ends up in the sustained person, if it's sustained, it goes in the personnel file. If it's unsustained, it goes in the G file or the 4522 G file for non-civil service cities. That's the purpose of it. And if not for any other purposes, for a civil service provision, it would be confidential.
So let me ask this. So this was another idea that I had about listing out at some point in here, whether it's training bulletin or we put in this policy on what goes in each file. Because I remember very early on when our entity became 143, we had to go split. So not that I had 1,000 employees to go through, but 40 files to split was a little bit of a pain. But I got basically a list of what goes in which one. So I guess my question is, doesn't it really kind of depend on what it is that goes in the file that makes it confidential?
Yes, what it is and kind of the results you get from the investigation. Right. Obviously, all the other things that are under these very specific categories of information that at the department level can be subject to public disclosure. Those are subject to public disclosure, can be at least. Obviously, the G file or anything that doesn't go in the A file.
Everything else.
That's everything else. Right. And that is to protect that that information is confidential to protect the privacy interest of the, and the reputational interest of the officer.
Only in 143 cities.
Yeah, but so one of my ideas is that, what if we did separate that? What if we did designate what goes in each one? For those that are not 143, I can tell you what goes in the A and the G file because I'm a civil service entity. But if you're not 143, how do you figure out what goes where?
I will propose this. I think that the statute, but in the 1701, both provisions mirror 143.089 very closely, if not almost identical. As far as contents, what goes in that A file, and again, really it only has to say what's in the A file.
Right, and everything else goes.
Everything else goes in G file, Chief's file, department file, whatever you want to call it.
It didn't have G, which is what we were trying to do, but only because the real reason is it states that you shall maintain it. Because what's happening is some of the 143 cities, well, it's slowly happening. It's not in the open yet, but it's being suggested that a 143 city not maintain a G file.
Correct.
So if we can somehow in this policy say you have to maintain records on employees, written reprimands, internal, if we can do that, that would be a great place to require them to do that.
I think that's a great idea. Let me speak to what you just discussed though, and that goes whether the existence, and I think we're talking the same language when we say if you have something that is created as a matter of law or is created by operation of this model policy and it doesn't fit into the specific categories of the A file information, and we're just using that for shorthand for civil service and non-civil service under the Sunset Bill. Everything is a matter of law. You can decide to have a G file or not. It doesn't matter what you decide. As a matter of law, that stuff is protected. You can call it whatever you want to. I mean, or you can say we don't have a G file. You do have a G file because you have information that doesn't go.
What about for the non-143 cities?
That's what I'm saying. Is these provisions mirror one another?
But it doesn't require. I guess is there a way to say Is there a way in here to capture if it doesn't fit, like you just said, if it doesn't hit on A through F, you're still required to keep information on the officer even if it doesn't fit A through F?
I think you can simply, and I think to accomplish that, you say that you have to retain that information in accordance with state retention laws and 1701. But if it goes into a hypothetical G file, whether you want to acknowledge that one exists or what are all those arguments, you still have that information and you still have to do something with it. It just doesn't, it's still protected information because it goes to the rights of the personal privacy and, reputational rights of the officer. That's been established case law.
It's not really standardized though, right? Like, because we were discussing, you mentioned something about a sergeant's file and there was something about, and I know it differs from Austin, there was something about, you keep it for 2 years and then it goes away. Where does it go and why is it 2 years? The other the cities who aren't 143 aren't,
right.
What are they doing with
Well,
it? And is there a way to?
And I think that's what we can address here. John, could you pull this up, please? This document and the chart. Let's go to this one right here. Can I just stand? Thank you, John. And we go back. This is what we've outlined, personnel file, and what y'all have on, I guess, everything up till G. Again, we're looking at the department level. This is all the due process of the roll it up real quick to the top, John. This is what we were discussing this morning. What does misconduct mean? And what is the obligation of the agency to have an investigation and come up with some findings, some conclusion? That's up here. That's what we discussed this morning. Let's go down, John. Document your completed investigation. You have your agency due process. Obviously, if it's sustained, it's going to go into that, what we call the personnel file, that A file under 143.089 or the new 145.35 for non-civil service cities. Sustained allegations and the other items, the positive letters, things of that nature, all going in that personnel file. We know what that is. That's the A file, and that's subject I'm not saying in every case or all information included, subject to public disclosure at the agency level. This is the category we're talking about and section G is talking about.
But also, it's not just talking about that. It's talking about things like that we discussed last time, and I know the chief was weighing in heavily on this, which is things observed by like sergeants or some type of supervisor that are observed that end up in a
It doesn't fit into here, because
No.
these are specific.
That's G file stuff.
Yes.
That's what I'm saying. So it's not just unsustained allegations.
No, correct.
It's a lot of other stuff.
That's correct.
So, I mean, again, my question is if we can address it somehow in this model policy for personnel files and we can.
What are you thinking, how to address that? I just want to put this up here so we all can visualize what we're discussing instead of just kind of.
Yes, I
I
agree.
don't think you're getting away with anything. I think John and I agree that this is a confidential database. When those documents come to us, they become confidential. They can only be shared with the
And I
release for the
guess
purpose of
what
hiring.
I'm talking about is things that don't necessarily come into this database. Because this is a personnel file model policy that doesn't necessarily have to do with the database. Right? I mean, not everything that we're discussing here is.
They're inextricably linked. I think agencies now, what we've talked about is when you separate, they will provide all those files, right? And you know that once you provide those files, they become confidential. All those things that a chief administrator would consider a review in the hiring process will now be shared. And so John's argument is, if it's going to become confidential and I'm keeping it for the primary purpose, the law requires me to provide that to TCOL to go in a confidential database. That while I
In
hold
other
it,
words, you guys aren't gonna share it.
while I hold it is confidential in anticipation of going into a confidential database. It only exists for the purpose of those people making an educated hiring.
I think some of the question is her example of, so we have a, sergeant's file, written counseling. Some agencies, I'm sure, they don't keep that indefinitely. They don't put that into like, for my agency, I usually, we keep it. I've heard otherwise. We were releasing them, getting rid of them, after 2 years or whatever. And then our employment attorney said, no, don't get rid of anything, keep it in there. But there are agencies across Texas that's their policy and their standards. We'll keep it for 6 months, you don't violate it, then it's gone. But it's a counseling. It doesn't get to the level of, what we're talking about misconduct. That's internal stuff.
But if I want to hire an officer who has that in his file and I come to your agency, you're going to let me look at that, right?
Oh, yeah, you get it. Yeah, you get it.
Yeah, and that's
what we're saying is at some point now, that's going to go to TCOL to be in a confidential database to be available.
at the request of the licensee who's potentially being hired. Right.
Yeah, but I think this conversation is away from the TCOL part, and it's looking at, we're establishing a model policy for personnel files, period. So is there a way to instruct agencies on what they should be doing with the other G file? I mean, obviously this unsustained allegation.
And everything else is what you're
And
saying, right?
everything
Yeah,
else.
I'm with you.
Is that if there's a way we can do that in this policy, especially if we're requiring it,
Sure.
then we're shutting down a lot of, random ways of keeping files and.
Agreed. It's the flip side. This is established case law. Abbott versus City of Corpus Christi. It doesn't matter if you have it in what you label it, the G file. You can call it the chief's file, the department's file, the whatever, the sergeant's desk file, whatever. It's irrelevant to what it's labeled or to where it's at. All this information is considered confidential if it falls outside of the specific categories of information here. Did that help? That makes.
Well, yeah, but if you read the last opinion that came out, that was ours, was they left that caveat in there. It was positive for us, but they left the caveat in there that it was only confidential because at the moment, they still maintain a G file, but that's permissive right now. So if for some reason they don't maintain, that's the AG left that kind of like, that maybe they're not going to maintain it in the future, and at that point, they're not ruling on that, in that particular ruling.
I understand, because that was that an open records letter request? Letter ruling on a specific, okay. Let's keep in mind too, that those do not have binding legal authority whereas case law obviously does. City of Abbott versus Corpus,
And
City
that
of
was
Corpus
cited,
Christi
that was
versus
cited
Abbott.
in the
And
ruling.
that preceded this legislation that created this other type of file retention, right?
Correct.
Not the, no, not the ruling.
The case did, but not the ruling, right?
The case was the case preceded, but the first ruling was after, and the second ruling was also after.
I will say
Not in
this.
effect.
Go ahead, CJ. Sorry.
Yeah, these files have not been created. This confidential database has not been created, so that is
But
it's
this
not
is-
contemplated
But
in
they're
this
not
issue.
trying to get it through the confidential database, they're trying to get it through the city.
That's
City
what
of
I'm
Austin.
saying. At the city level, it's absolutely, that's what I'm saying. But you can claim everything that's outside of this. You should be making the claim that if it doesn't fall into these categories, it's confidential.
It's now being retained to go into a confidential database as required by law. This is a new entity that requires you to keep these records and that they are going to be confidential when they come to the state. So why would they not be confidential while they're in your
Well,
custody in
because
anticipation of going to
this
the
says
state?
unsustained allegations file.
Because we're talking
So-
in this context
I
of
know.
what needs, what.
There's other stuff.
Correct. And that's the broader document view. This, for the purposes of this flow chart and misconduct allegations and those investigations, that's why
You
this
could
is
make
labeled why it's labeled.
Yeah, what I'm saying is there's other things outside of this flow chart.
Understood. Yeah. Stipulate.
I mean, and that's, if we can't address it, we can't, but if we could, this would be a nice place to do
Let me
it.
ask you this, how would you address it? Is it
That's what I was trying, I'm the
confidentiality?
one who added G, so originally Chief and James only had A through F. So I'm the one that added G to this model to try, and that's why I asked what you thought about it, cause I just don't know, you know, if that's something we can do here. I would think it would help clarify that.
Create the file, is what you're saying.
Require that you maintain the things outside of your flow chart in G.
You know, and I think we can, and I get it, and I don't see it on here, but I added under under C1. Like alleged misconduct by license holder may not be placed in license holder's personnel file if the agency determines that there is insufficient evidence to sustain a charge of misconduct, and I added, and it must be maintained.
And what number was, James,
That
where was that?
C1. Because that was my concern. That's the only, that's all the other things outside of A, the A file. So that's everything that we're talking about that, you know, that would then create the G that they have to have it. We all agree that they do, but I'm not sure that every entity, when somebody comes in and makes an allegation or, you know, a written reprimand is provided, you know,
I guess,
they keep it do they keep it maintained? That's as an agency administrator, that would be what I want to see. So I can assure you that there are places around here that someone may come in and make an allegation, the employee says, I'm out. And there's not a piece of paper that has anything to do with that.
I think that would cover it as if we expanded alleged misconduct, which I don't know if we want to do because we took it straight out of 143, but alleged misconduct, I think the internal discipline stuff is not really always considered alleged misconduct. Just because your sergeant reviewed a video and says, that could have been done better. Here's a written, or here's a oral counseling or whatever. That's not really alleged misconduct.
Yeah, I'm sure we could change the wording there.
But I think if we kept G that I put in here is it's not exact 089G, but it's close. And it covers the internal file. I mean, we could call it an internal file. We could call it something other than employee development. That is what a lot of agencies call it, because that's what it is.
Let me look back at the 143.089A. Just a minute here. Let's think about the components here. Must contain a commendation, congratulation, or honor. Must contain misconduct from employing department that resulted in disciplinary action by employing department. must contain periodic evaluation by supervisor. Document relating to an alleged misconduct may not be placed in the personnel file, which is the A file, if there is insufficient evidence to sustain the charge. So must put certain items in this. So what happens to everything that falls outside of that? That's the discussion we're having. It has to go in either the G file. If you have anything.
We don't, like James is saying, we don't really talk about G file in here, except for we added G, which, do you know what I mean? Like,
No, I'm with
we're
you.
not giving them the instruction that this model policy.
No, I'm with you. I'm just working through the principle here. I'm with you. Everything that falls outside of quote unquote personnel file for the purposes, and do we have everything that's required to be in the personnel files already set out under this, right?
Yep. Foundation, congratulations on
Yeah.
it.
Yeah. Good, step by step. So if it's, I think this is just my initial stab at it, is all other information must be maintained in another file.
Like internal file, or how do we?
I guess you could call it, I think if you wanted to get specific with it, in the spirit of the Sunset Bill, the 1701-4522 file. I don't know, something along that nature. You could cite, but then you want to have a label on it within the policy that's a little more user friendly. What's in that can? Oh, I see. Okay. That's fine. I don't know. I guess for purposes, maybe discussion, leave departmental file in it now, if the concept is.
Employment file.
Yeah.
I mean, I can tell you a lot of them call it employee development file. I don't know if anybody here calls it that at their agency, but that's common. Because it's basically the information, like you said, about their, I guess reputation's one way to put it, but starting as a rookie, you screwed up here, you screwed up here, as you go along in your career, but none of it is alleged misconduct. None of it is anything that would go into this flow chart in any way. But it's how you develop them, and that, I know the chief, he's gone now, but was trying to say in the first meeting, that's a pretty sensitive file, because that's how you develop an officer. If that's all of a sudden free for everybody to see every time that they've ever done anything that was involved some kind of counseling or anything, then that's really problematic. So
let's
be done here.
Let me propose this: is if we may, to incorporate these confidentiality adjustment for non-civil service cities, and to have language that maybe encompasses all information outside of the obviously unsustained allegations file. Can we work on something similar to what TJ and DJ are working on with? I can work with whoever, and we can see if we can kind of reconcile. We're speaking the same language here. We just got to get the specifics down.
Okay, I'm not opposed to that. Who would like to work with John and Jennifer? Okay. So we'll table that for now. I think we have a pretty good understanding of where we want to go and some of the nuances and challenges involved, but you guys will flesh it out a little bit and bring it back to the group for consideration.
Okay.
Is that accurate?
John, and we may have talked about this, if an agency adheres to the state retention schedule on a separated employee, that they forward that personnel file to TCO. So we're going to destroy it at the time, right, on the schedule, but it's still going to stay in TCOs. Is that right? Or is it going to adhere to the state retention policy.
We'll adhere to the state retention policy to the extent, I'll defer to Jessica on that, how long we need to keep it in that database. Whether it's a transitory nature of it, or if the department is still going to obviously need to hold on to those records. I'm not necessarily sure. Are we thinking that once it gets transmitted to TCO, then TCO is on the schedule at that point and the department's relieved of the schedule? Or, I'm open to anything, I think that's a good point.
I think the agency would still have to maintain theirs for their period. I just didn't know, like, I think it's 5 years, right? For an agency, if we destroy ours in 5, is TCO gonna destroy theirs in 5? And if not, that agency's gonna, some other agency's gonna inquire and we're not gonna have anything.
Correct.
At that point.
I think our officer record retention is something like the life of the officer plus on a lot of years, like something like 70 years.
Big database.
A lot of storage.
Did that answer your question?
Yeah, I just wondered how that's gonna look, that if we destroyed it based on what the retention schedule says we could do, and the agency that's hiring this officer reaches out and they get it, and then they wanna contact us for more information, and we're like, well, we don't have anything, because we destroyed ours.
That's a great practical question.
Under the retention schedule.
No, I think Jessica's spot on, we're on the hook for it.
Well, good, I can tell my department to start throwing stuff away. We keep everything from all the time.
It's not bad practice.
We've got everything.
Okay, other thoughts on that policy, personnel file policy?
You noted H, where's H? Yeah. Or is that just something you copied on G? You refer to H?
Hang on one second.
I didn't get H.
Cut and pasted from 189.
Yeah, 080,
Nothing changed.
yeah, that's, H is the prospective employer.
Okay.
So they can access the information, which they would already be able to. That's kind of what we were talking about here.
And this is just a mental note for us as we work through that proposed G, is instead of referencing the subsection, we'll put unless, what does H say? That's for the written consent provision, right? We'll go ahead and spell it out, unless upon, or whatever language we want to use, whatever actually subsection H says.
It says, I can read it to you. It says, as provided by section 1701451 Occupations Code, a law enforcement agency hiring a police officer is entitled to view the contents of the officer's personnel file maintained under subsection G.
And we'll just put all of that in there to spell it out completely.
To spell it out. And 8G, actually, if you wanted to use the exact language, that would work. You would just have to take out firefighter and change may to shall.
And the shall being,
Maintain it.
yeah. And the shall
So
coming
it's not permissive that you maintain it, you shall maintain it. Which is probably better than using employee development because not everyone uses that term. And then it would be coming right out of 143.
Okay, other thoughts on this?
On this policy 2A, we need to take the language that we created under the misconduct allegations about negative letter and move it over to this policy, including the 7 days that we had already agreed upon.
Jennifer, Jason, John, is that something you guys can incorporate into whatever changes you make in this policy? Or
Yeah, I don't think it impacts it, right?
And this was the notice and due process
Yes.
provisions.
Yeah.
Yeah,
rather than having,
note on where to, yeah, we've got the note on where to.
okay.
I'm trying to think, there's no reason why we would need it in both, right?
No.
That's why they took it out of the other one, they put it in.
I know, but I'm just like making sure there's no like hypothetical we need it in the other one. 'Cause the other one's just the reporting to TPOL eventually. This one's like what they're maintaining. This one essentially would be reported as well, yeah. I'm just thinking it through.
And we can
It only goes
clarify
here.
that the other policy is misconduct, allegations, investigation, and summary report.
Mhm.
Just that is the limitation of that model policy.
Right.
All of those would be negative items, but there could be additional negative items, so putting in personnel files captures the rest of those possibilities.
That's right.
What did you say to title it, TJ?
What I said was misconduct, allegations, investigation, and summary report.
Yeah, just to limit it.
Yes.
Cullen brought up a good point on the going back to the records retention. Would you read it, Cullen?
Under 1701-453, maintenance of reports, the commission shall maintain a copy of each report submitted to the commission under the subchapter until at least the 10th anniversary of the date on which the report is submitted. So it's submission plus 10 is the minimum resident here. So if it falls under archive somewhere else where we've got to keep it longer, but 1701 says it's at least got a 10-year shelf life with us.
And that's the personnel file, or that's a summary report of misconduct?
This says the maintenance of reports under, it would be the reports generated from the misconduct.
Specific to the misconduct.
Sorry.
Specific to the misconduct reports.
Is that accurate?
I think they need to fall to our retention policy on
Yeah,
officer
agree.
records, which is beyond the 10 minimum.
Yeah, agreed.
Other thoughts on this? None? Okay. I don't have the agenda in front of me, but I think this was the primary things that we needed to cover today. Can you confirm? Cole? I mean, we have 3 model policies that we're working on. We hit all 3 of them. I think next steps, I guess I could have got up myself, I'm sorry. Thank you. So from my notes, next steps are gonna be, Iris, if you don't mind sending out the stuff that we talked about this morning to the group, some of the changes, we made a handful of changes to the misconduct allegations model policy. If you don't mind sending that out, we can all take a look at it and review with our folks back home, see what other changes may be necessary. With regard to the background investigations, TJ's plural are gonna work on some of the language with regard to BCF and the minor modifications of the NDI. And then the personnel files policy, Jason, John, and Jennifer are going to incorporate the other changes that we identified with regard to the misconduct policy incorporation, as well as flesh out what we need for that bottom section regarding some of the transference of 143G protections to those that don't have it. Is that accurate?
Yeah, is there any way we could get, either you or Chief Sandridge to send us the model policies or any language that we've agreed on so far. Just together, so I know, because there's a lot of moving copies out there right now. So that we know what we've agreed upon as of right now, so we can have others review it, so that next meeting we'll know for sure if there's any extra feedback or, because I've got like 3 different versions of the personnel files one right now. And I just wanna make sure we're all looking at the same agreed upon, even though it's not fully agreed upon, but the last one,
Understood.
the last
December
project.
version.
I think we'll send you the updated version and it gets sent out from you guys and we go from there. Happy with that?
If you get it from Chief Sandridge or I, then it's the latest. And we'll do that as soon as we get something from Iris. We'll do that as quickly as possible so that you guys can get working. Other comments, questions, concerns about any of that? From anybody? Okay. So that's next steps. We have discussed the next meeting date and location. I think we identified January 10th as the next date. Any other comments from the group? Carlos, you've been kind of quiet today. With that, I think we are moving to the public comment section. Any public comments? No? Okay. And with that, if nobody else has anything else.
Language for the next meeting, do you see it keeping it the same, or do you wanna add?
Yeah, I think for the next agenda, it will be to follow up on the proposed 3 policies. I mean, I think we're making good steps. I can give you more specific language if need be, but the plan for next time will be to get the feedback that you guys have worked on at least a week beforehand so that we can then talk through finalizing the 3 model policies. Does that work? And Iris, does that give you enough to go on? Okay. With that, I think we're done. Adjourn.
So moved.
Second.
So moved. Or whatever.
Thank you all.